May it please your lordship. Item number 48, my lord. Adjournment. The interim order is there, that may continue. Can it be on 10th to 11th of November? When the interim order to continue.
Item 1 for motion.
May I please, my lord? My lord, the present respondent number 1, my lord, file a probate case before the session the 6th hour, whereby the present appellant was present before.
Order in probate.
Yes, my lord, till then, my lord, yes, my lord,
Hello.
till then, my lord, the interim order will be, IA was there, sir. My lord, what happened, my lord? It is that one kind of act party order, my lord. After filing the written statement, my lord, the present petitioner was failed to appear before the lord. It may come to page 16, my lord. 1 6. My lord.
What is the illegality?
Yes, my
Why
lord.
should it be stated?
My lord, basically, my lord, because after filing the WS by the present petitioner.
No, that's why I'm asking, what is the relationship of the parties? Who is Prakriti Das?
My lord, property there.
First, tell me whose will it. First, tell me whose will it is.
My lord, it is the uncle.
Sorry,
And
we don't know uncle and aunt name. Name of the person. Whose will is it?
yes, sir. The Anjali Mukherjee.
Anjali Mukherjee.
My lord, Anjali Hazarika.
Anjali Hazarika Mukherjee. Her will. And who is Prakriti Das?
Her property.
Please come prepared.
Lord, and
We are adjourning time being. Please prepare. Give me the information whose will it is and what is the relationship between the petitioner and the respondents with the person who had executed the will. Next item.
Item 2.
Please, at least this much information, make note and please tell me. Yes.
It is a transfer petition filed by the wife lordship for transferring a matrimonial suit from the court of the land and district of Dibrugarh to Tinsukia lordship.
On why?
Petitioner is residing at Dibrugarh lordship. She is residing along with her elder brother lordship without any source of income lordship, and she has.
And the husband, where does he reside?
He is at Dibrugarh lordship.
Dibrugarh. And you want to transfer to Tinsukia?
Tinsukia lordship, because I am residing at Dibrugarh lordship with my elder brother who is heart patient lordship. Recently he has undergone one major heart
That
surgery.
is okay. Is there any other, what kind of a
Yes,
suit is
yes.
this?
This is a matrimonial suit, divorce filed by the husband lordship.
Divorce filed by the husband.
Yes, lordship.
I heard MS P. Vattarji, and counsel for the petitioner. Notice 6 weeks, extra steps by registered post, 3 days. The petitioner seeks for a transfer of title suit divorce number 71/2021 from the court of the learned district judge Dibrugarh to the court of the learned district judge Tinsukia, on the ground that after living separately, the petitioner is residing at Dibrugarh without any source of income, along with her elder brother, who is also a heart patient, and therefore she would be highly inconvenienced to travel to Dibrugarh to attend to the divorce suit. In view of such submission, further proceeding in title suit number 71/2020, title suit divorce 71/2021, pending before the learned district judge shall remain state.
Obliged.
Item 3,
Yes, item 3, Mr.
Yeah, last order, my lord. Yesterday we have filed
Hmm.
regarding my lord, violation of the boundary mark. We have filed affidavit, my lord, stating that there is no compromise. And we have also annexed the site plan and my lord, NOC. So last order, my lord.
end of the day.
You have filed affidavit.
Yes, yesterday we have filed.
Is it on record?
Not in your government. Yesterday we filed because.
It is stated that in response to the order dated 16/11/2023, an affidavit had been filed by the petitioner, which is not on record. List along with the affidavit dated at the next.
Item 4,
We are listing it. Your list. Item 4, who is appearing?
Vice Chair Kalam.
So there is a order of stay of the implement.
Early interim order to continue. None appears for the petitioner adjourned.
Item 6,
Which pleases your lordship. Lordship, this petition has been filed against the order of the learned trial court rejecting the petition filed by the petitioner for order 26
Wait.
rule 9 of the CPC.
Where is the order dated 21/7/2023?
Lordship will find that page 34, Lord,
34.
the impugn order. The prayer for appointment of commissioner was rejected by the learned trial court.
Order 26, rule 9.
Rule 9,
What is order 26, rule 9?
appointment of the commissioner, commissioner.
I mean, commissioner.
Yes. To ascertain a nature of a land. Dispute is related to enforcement and boundary dispute.
You are for the defendant or for the plaintiff?
I am for the plaintiff.
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 Why do you want a commissioner?
Lordship, the dispute is that.
Dispute I know. Defendant has taken a stand that Schedule B is not a part of Schedule A.
Schedule.
It is part of some other land.
Yes,
It is for them to prove their stand. Why do you want to get into the matter? Appointed commissioner.
my lord, my claim is that they
Your,
have encroached my
Mr.
land.
Counsel, as a plaintiff, you will prove your case. Defendants, they will prove their case. If it is the stand of the defendant, Schedule B is not a part of Schedule A. Burden of proof is on them to show it.
Lordship, if they.
I
the
think this
commissioner
order is it's a right order.
My lord, if the commissioner is appointed. it
No,
will
no.
Expedite the trial.
Commissioner is not to be appointed merely on the asking of a party. Read Order 26, Rule 9. Local investigation to be requisite or proper for the purpose of elucidating any matter in dispute.
Yes.
If the defendant has taken a stand, they will prove it. If they cannot prove, you will be the beneficiary. Why do you want to interject the proceeding with a commissioner?
It would expedite the trial. my
I
lord.
think you are
Just to
doing,
ascertain, my lord,
Mr.
who-
Counsel, you are doing more harm to your client than benefit. No doubt you have got a matter if you have filed a petition. It's a good client for you, but you are doing more harm to your client. If the defendant cannot prove, you will benefit by it. Only at a later stage, if they prove with some disputed material which requires elucidation, then you will go for commissioner. Why at this stage? Court has rightly rejected it.
Lordship, no
So
legal-
what will happen? If the defendants cannot prove their case, you would have been a beneficiary. But because of the commissioner, it is proved against you. Will you not be at a disadvantage? Then why are you going for it?
Clarify.
Who advised you to go for this, commissioner?
Just to ascertain.
Have you and moreover, Order 926 is for the court. Where the court deems a local lives there, it's not any right of any of the parties. Court, after having the materials before it, if it feels that for proper elucidation it requires a commissioner, the court will appoint. Not at the asking of a party. Read. The petitioner seeks for an adjournment to examine the scope of Order 26, Rule 9 as to whether in the present case, it is a fit case for exercising the power to appoint an commissioner. This response.
Item 7,
Date may be given.
22nd.
Obliged.
You'll do more harm to your client, Mr. Counsel.
My lord, no liberty was also given
Not required.
to, if any.
It's not required.
requirement arises, then.
It is not
subsequent-
required. That will protect
the
you.
subsequent-
Rejection shall not be. That will protect you.
Before timing for item number 7.
Item 8,
Agent.
7 to adjournment. 8. Yes,
My lord,
which
the-
order?
Impugn order, lordship will find at page 43, ma'am.
42, 43.
Therefore, filing of detailed statement of the defendant number 17, whereas I am present petitioner has been rejected by the learned trial court. Despite my illness, I could not send the document to my lawyer on that particular. And some relevant documents, those are not in my possession at that relevant point of time.
So, who asked you not to file written statement for almost 1.5 years?
My lord, in the meantime, this impugn order was challenged before this honorable. court, but
Which
due to
impugned order?
This 16 July 22, sort of.
16 July was challenged before
Challenged.
this court. Then
But
what
due to-
happened?
Due to some wrong implement of the parties, the same was withdrawn and again file afresh on last.
No, no, whatever it is. You entered appearance on 23rd March.
What's the quorum?
Up to 16/7, why you are not filing the written statement? It's all more than 4 months.
Yeah, because some documents relevant for filing of the.
So now, because of your wrong impleading of a person, then now filing this revision after 1.5 years, see the delay you have caused to the suit.
I have, because there are many defendants, service supposed.
It doesn't matter. We are on with a petitioner. We are not only many defendants. You have caused a legal injury to the plaintiff.
Yeah, দেখাটেখি সব তো মিথ্যা
My lord, there are no.
What is the value of the suit?
No issues have been framed. with the-
May not be framed. What is the value of the suit? No idea.
I am checking the play.
Counsel difficulty is the lawyers prepare only the few words they want to say to the court nowadays. They are not even ready to go through the entire brief.
1,000, ma'am.
Huh?
Only 1,000.
1,000 is the value of the suit. What kind of a suit is this? Suit for what purpose?
Suit between for partition suit most probably and the right declaration for right title.
Suit for partition.
I am not filed the plaintiff.
I know plaintiff have filed. What is the value of the suit property?
So far as the plaintiff is concerned, at page 33, I am finding only 1,000 rupees.
1,000 rupees suit value. Something is wrong somewhere.
But, certified copy of the.
Mr. If the value of the suit property is 1,000, we'll require Mr. Mahmood to purchase the property with 1,000. We'll pay you for the, he'll purchase it. Will you agree? Hmm?
It's not my part.
Will you agree to sell your property?
It is not my property.
May not be whosoever it is. Will you agree to sell it for 1,000? Then how can the value of a suit property for partition be 1,000 rupees? Hmm. Declaration also has a value. Declaration is not at a throwaway cost. Anyway, how much of land?
My lord,
How much of land?
land is some different schedule have been drawn in the plan. Schedule for different.
Come prepared. The petitioner to state the exact description and amount of land that is involved in the present litigation. Next item.
Item 9.
Can it be please, sir?
Mr. Counsel, we'll allow you to file written statement. You'll have to pay a cost. To evaluate how much cost, we want the value of the property. How much you have gained by delaying it. You pay, go and file written statement. Further, the petitioner to serve dusty on the respondent and thereafter file affidavit.
Okay.
Yes, Mr. Sheikh.
Thank you, Your Lordship. My lord, I want to produce some meat, my lord, in the.
Some
my-
deed.
Yes, my lord, that was rejected, that is at page 64, my lord.
64. Why was it rejected? What ground?
Is rejected, my lord, that delay. No
The deed is the
specific
day fixed for the order on
satisfactory
petition.
circumstance, not producing. Last but first paragraph.
This petition is filed under which provision?
My lord, provision is not mentioned.
No, anyway, which
Lord,
provision
uh,
will govern the filing of evidence at
I
a
will
later
refer
stage?
to, my lord,
Hmm,
I will refer to Rule 14 of Order 7.
Order 7, Rule
Yes.
14. Okay, we are issuing notice.
Hello.
Issuing notice.
Not issuing notice, but
You don't want. Then
but
dismiss.
that further proceeding is to be statement. Because evidence is going to be proceed.
This is
Evidence
not a
witness.
ground to stay a suit.
Well, only thing is this, my lord, my,
You go and serve dusty on the respondent, we'll hear them and we'll pass our order.
my lord, it is as per impugned order, my lord, it is fixed on 6/11/2023. That is.
That is
over.
gone.
So, my lord, that is for DW.
Hmm.
That is for DWs, my lord. Now DW will proceed,
No, you only want to produce one sale deed.
my lord.
If there is no bar under the law, will allow you to produce it. But why should a suit be stayed for that?
Thus the service will be done.
Go serve dusty,
Yes.
listed before the next day. Will, if the defendant appears, we'll hear them, why they are objecting.
Yes.
We'll also examine your plaint.
Okay.
Whether, did you make a mention of this sale deed in your plaint?
My lord, that is not mentioned in the plaint, my lord, because, my lord, I.
Then
got
why
this
do you want to?
Subsequently,
No, no. I have not understood your case.
Hello.
Why do you want to bring on record this sale deed?
my lord, the reason is this, my lord,
Hmm.
in the plaint, my lord, my claim is this share of my father's property. And this
In the
land,
plaint, you claim share of your father's property.
father's
Defend-
property, that is 1 katha, 17.
Okay, so now what is the relevance of the sale deed?
My lord, my father purchased that plot of land. That sale deed relevant to the land which was purchased by my father.
Your suit is for share of your father's property.
Yes.
Later on, you came to know that father also purchased a plot of land by the sale deed.
Yes.
So you want to include this claim also in your,
In my evidence,
where is your plaint?
my lord. Plaint starts from page 40, my lord.
40.
Okay.
So I think you need to file for amendment of your plaint. You have to file a petition for amendment of your plaint because your plaint says declaring a right title over C schedule land.
Yes.
So possibly now you later on came to know that your father had some more property.
My lord, the property I have already specified. That this much of.
No,
property-
is the sale deed related to schedule C?
Yes, my lord.
Hmm?
Schedule C, my lord. Total property.
What is schedule C?
My lord,
Land measuring 1 kotha 7,
17 less.
part and parcel of A
schedule
and
land.
B schedule.
Yes. Schedule C is the claim of me.
By
share.
no, it cannot be because schedule C is a part of schedule A and schedule B.
Alright.
And schedule A is covered by some khatiyan.
Alright.
And schedule B is also covered by khatiyan.
Yes.
There is no relationship between a sale deed and a khatiyan.
Yes, my lord. Because, my lord, this.
Khatiyan is a document issued recognizing some right.
But,
Sale
those
deed is a
khatians-
document by which a man purchased some property.
my lord,
They are not interrelated.
I am trying to answer your lordship. schedule is Khotian land, my lord, purchased by my father. Purchased by
Where
my
is the
father.
sale date? Let us see.
Sale deed.
Take it. Let us
Sale deed I have annexed,
page number.
page number 19, my lord.
Page number. Yes. Heard Mr. M. Sheikh Land Counsel for a petitioner. The petitioner as plaintiff instituted TS 26/2012 amongst others for a decree declaring right title and interest and possession over C schedule land in respect of 1 quota 17 lessers as his share as per the Muslim law of inheritance. Schedule C is a part and parcel of the Schedule A and Schedule B land, where Schedule A land is a plot of land measuring 2 bighas 90 quota 9 lessers covered by Khatian number 131, Dag number 5 and 6 at village Kazipara in the Dhubri district. At the time of rendering evidence, the predecessor in interest of the plaintiff and the defendant acquired right title and interest over the Schedule A land by means of a sale deed number 592 dated 8/4/1992.
My lord, as well as,
Please.
as well as sale deed number 1474.
Don't interrupt, please.
I'm sorry, my lord.
Whole thing goes out of my mind. I always request Mr. Sheikh, and you always do the same thing.
Sorry.
You are so enthusiastic. Can't you add one word at the end of the order? Do we ever refuse you? Then what is the necessity of disturbing the entire flow?
I'm sorry, my lord.
You are sorry, but I have to now argue again. I've forgotten what I wanted to say. The link is gone. Now you argue once again. I'll formulate your order once again. Yes.
My lord, your lordship. will
See,
grant-
we need a lot of concentration. This is not a very easy work to do.
Yes, my lord, I do agree.
Understanding the case of 50%, that to a civil matter, is not a easy work.
Yes.
Where learned counsel, we have seen from the morning, are not even prepared in one case. How do you expect us to deal with it? And if you break our concentration, how do you expect us to proceed ahead? Yes, start from the beginning. I'll hear you again.
My lord, your lordship.
Or else let us adjourn it. We'll hear you on some other day.
In that case, my lord, notice may be issued, I will post the service on their party.
We thought of something much better for you. And you,
I'm sorry, my lord.
but your sorry will not bring it back to me, what I was about to dictate, that complete formulation of the order, it will not bring it back by the word sorry. So you argue once again.
So, my lord, in that case, my lord, your lordship will turn to page 19. It is the sale deed, my lord, by which my father purchased a plot of land measuring 1 bigger, 2 kata, 19 lesser. That is at page 20. Thereafter, what happened, my lord? On the same day, another deed was executed. That is at page 25. By which another person purchased a plot of land out of the same A schedule land, my lord. 2 kata, 10 lesser. And thereafter, that 2 kata, 10 lesser of land, my lord, was sold to my father by registered deed number 147. That now the question, my lord, regarding this, I want to produce deed number 592. Before the claim. The 592 land was purchased by one Surman Ali, and Surman Ali sold that land to my father by subsequently on 2895 by deed number 147. So now I want to produce this deed, 590. That has been,
Will you issue notice?
Hello.
Notice returnable for, when do you want returnable on? You also take justice service?
after 2 weeks, my lord.
Returnable on so steps were registered post as well as by dusty method to the registry of this court.
I'm appearing.
Response rate.
1, 2, and 3.
MSP, just APS correspondent 1, 2 and
3, 4, 5.
Obligor.
Item 10.
This petition is preferred against the order passed by the landed executive court allowing the petition of the decree holder and rejecting the petition of the judgment debtor. And decree holder sought to execute the remaining portion of the land. Already half portion of the scheduled land has been executed.
sorry, 3, 10, 20, 23, which page?
Page 84, my lord. Two applications were there, my lord. And both the applications were disposed of by the same order, my lord.
Who filed this petition? 360 petitioner.
361 was filed by the judgment debtor.
And the petitioner is?
Petitioner is the judgment.
You are the judgment debtor.
Yes.
And the
And-
360 is filed by the judgment debtor,
Filed by the decree holder
decree holder. And
Against me.
for what purpose?
for issuing press read, my lord. Because once.
No, both of you are making the same prayer.
No, I am praying that the compromise decree which was entered, that may be recalled. Because that was obtained on the ground of fraud. That was my petition. And their petition was that
Just a minute. Compromise decree was obtained by fraud.
Yes.
Where is your petition? 361?
it's at page 63, my lord,
63.
63.
Hey, there is now 1994, 1 SCC page 1. Page 1. Which page?
My lord,
Page number, your
Yeah.
petition,
63. my lord.
63. Where is the statement that it is obtained by fraud?
Yes, my lord. Paragraph 3. May I read, my lord?
Compromise deed was executed in a fraudulent manner. Why? What is the fraud?
Yes, my lord. That
Mhm.
is at page, paragraph 8 and 9 at page 66.
8 and 9. No, these are disputing fact. Where is the judgment debtor by suppressing? You are the judgment debtor.
Yes, I am.
By suppressing the actual existence of their land, instituted frivolous litigation upon the. Huh? Please read page 66, para 9.
The judgment debtor states that the decree holder by suppressing.
Or the decree holder by suppressing actual existence of their land. So why have you filed application under 23 Rule 3?
Rule 3
For what purpose?
Recalling, my lord.
Where is the provision to recall? Okay, let us take up the next matter. You prepare yourself.
My lord. And other parties also there, my lord, because their application that is,
No, other part we'll see. We are interested with your petition.
of course, my lord. And
You have taken a stand
Yes.
that compromise was obtained by fraud.
Fraud.
Very well. So you have filed an application under Order 23, Rule 3 to recall the compromise decree.
Yes.
Where is the power under 23(3) to recall a compromise decree?
Yes.
23(3) is only to effect a compromise in a suit.
Yes.
It's not a power to recall.
recall.
What will be your remedy?
I'll see, my lord. I
Mr. Sao, we have the answer, but what will be the remedy according to you?
separate suit perhaps.
Hmm.
A separate suit. But there is a judgment perhaps, my lord. I'll.
Where is the judgment?
My lord,
Produce it
So after sometime.
after some time.
Item 12 for admission.
This is the ERA appeal mail. We have filed two IA mail. One IA for lip petition mail, praying for in the substantial question of law on record.
Each Saikya seeks my journal provide a memo of appeal, the substantial question law. Where is the substantial question of law?
We have filed by, we have two IA mail. One is lip petition.
Where is the IA?
Yesterday filed by, it is not.
Not
on
there.
record.
It is stated that some interlocutory application has been filed to incorporate the substantial question of law in the memorandum of appeal, which is not on record. List along with that interlocutory
We
application.
have prayed for on 22nd.
Item 13.
Well, this appeal was filed along with three other appeals as analogous matters. The
We-
other three appeals, they order has been passed. Notice was issued.
So we admit this appeal.
Other appeals were not admitted, my lord. Notice.
Only notice,
Notice.
not yet admitted.
I
Why
had a
not?
Prayer for stay.
No, no. Why it is not admitted?
Lordship may ad-
Normally, civil appeals
Yeah,
are to
yes.
be admitted.
Yes, Lord.
Only in writ petition, we issue notice for a different purpose.
It was my duty to point out to your lordship that the other analogous matters, this order has been passed.
Under the
There is a-
CPC, is there a scope to issue notice and hear the respondents,
no,
whether
no.
it should be admitted
Yes,
or it should not be
has to
admitted?
my lord. First appeal.
We either we admit or we dismiss.
Yes, yes.
On what ground you have filed this appeal?
My lord, this, what happened, my lord? The
Mhm.
there was an arbitration proceeding between the respondent number 2 and respondent number 3. And an award was passed.
Arbitration between respondent 2
No.
and 3.
Respondent number 2 and 3.
2 and 3 means Bharat Heavy Electrical and
And Billward.
Billward is 1, not 3.
Hello?
Billward is respondent number 1.
Yes, Billward is respondent number
You say between 2 and 3.
1 and 2.
1 and 2.
I'm sorry, between 1 and 2.
1 and 2, there is arbitration.
Yeah, arbitration proceeding.
Uh,
And an award was passed in favor of the respondent number 1 against the respondent number 2.
uh,
To satisfy the award, and execution proceeding was filed. Money execution case. Actually, there were 4 arbitration proceeding. Accordingly, 4 money execution petitions were filed.
Okay, after the arbitration award to
Yes.
execute
Yes.
money execution was
Yes,
filed.
money
Yes.
execution cases were filed
Hmm.
before the learned district judge Kokrajhar.
Hmm.
What happened? To realize the amount, to realize the decretal amount, the respondent number 1 filed an application under order 21 rule 46 for garnishee.
21,
Rule 46.
46. What is 21, 46?
It's garnish regarding garnishee, my lord.
Hmm.
Application has to be filed under rule 21
41,
rule 46.
21, 46.
Yeah.
Attachment.
Yeah.
Attachment of debt, share and other property not in
Not
possession of.
of the judgment debtor. The
Just a minute. A
yeah.
debt not secured by negotiation sharing. So they have filed an application under order
21.
20 or rule 46.
Yeah.
The respondent number 2.
Yeah.
And
And-
who is the judgment debtor? Respondent number 2.
Respondent number 2 is the judgment debtor.
Judgment debtor.
Yeah.
So they filed it. And then after that,
After that, since the respondent number 2 was executing some contractual works under me, I am not a party to the proceedings, my lord. I am a garnishee.
what is garnishee?
Garnishee, well, lord, to understand it in if I am indebted to the judgment debtor, I am the garnishee. If I am required to pay some money to the judgment debtor, then the court may issue notice to me, directing me to make the payment to the decree holder instead of the
No,
judgment.
but who will establish the debt?
Yes, that's what, my lord. I filed an objection against the petition. And
No.
Right.
Suppose number 2 is doing some contract work under the appellant.
Yeah.
And accordingly, they claim that they are entitled to some money from the appellant. Somebody will have to determine.
yes, my lord, the procedure is such, my lord. When such an application is made, a notice under order 21 rule 46A is sent to me, to the garnishee, calling for objections from the garnishee. And if I dispute the contentions of the petition, my lord, the executing court is required to frame
No.
issues.
Now they have invoked under order
46,
46
order 21
rule
rule
1,
46 capital B. They have invoked
A,
directly
B or C.
B, because I have disputed it. They did not go to C even.
No, Mr. Counsel,
Yes.
Read the entire.
Yes, my lord. Where the garnishee does not forthwith pay into the
No,
amount.
why are you reading 46B?
Correct. I'm reading 46A.
First you started 46.
Okay. Attachment of debt, share and other property not in possession of the judgment debt.
Attachment of not in possession
Of-
in case of,
In case of a
number
debt
one,
not secured
just
by
a minute. Number one, debt not secured.
by a
Number two,
negotiator.
share in the capital of a corporation.
Yes.
Number C, other immovable property not in the possession of.
Movable property, madam. Other
Ah.
movable.
So now they have, respondent has made a claim under order 46,
Ah.
rule 46, 1, A, B or C.
They made a claim under rule of order 1, rule 46A, 46, madam.
46, 1, A, B or C. It cannot be everything.
It's from their application, it appears that they have made it under order 46 C, madam. Or rule
C.
46C.
Other movable property.
Yeah, other movable properties, they want to say that since the,
No, no, no.
yes, madam.
Is there any attachment order passed by the court?
Yes, madam.
Where is the attachment order?
My lord, your lordship will only come to page 22.
Page 22.
Issue notice to the director, executive director, last paragraph.
Just a minute. It
Page
appears from the recorded notices were issued.
My lord, what has happened that
Just,
learned executing court has passed in two
Just-
separate
just-
interlocutory applications. my
just a
lord.
minute.
Yes.
So this is an application by
By the respondent number 1,
Billward.
Billward.
And they are the judgment debtor. Billward is the decree holder or
Decree
judgment
holder.
debtor?
Billward is a
Decree holder. Just a minute.
Yes.
Judgment debtor is
BHEL.
the Bharat, the
Yes,
heavy
Bharat
electricals.
Heavy.
So they want the managing director to be taken into custody, civil prison and direction to the executor not to release payment to so and so.
Yes. This part is connected to me, madam.
Understand, it is stated that the decree holder has come to know that is this the impugn order here?
No, impugn order is at page,
Just a minute. We'll come to that.
Yeah.
So this order is okay. Now after that,
after that, I filed my objections. A notice was issued to me.
understand
Yes, notice
Ah.
was issued, notices at page 24, my lord.
very well. What objection you raised?
I raised objection that the amount they have asked me to withhold, my lord, whether that amount is payable to the.
So you denied,
Yes, I
denied that
denied.
we had okay, then after that, what happened? What
After
order
that-
was passed?
A hearing, there was a hearing
Ah,
and the impugn order at page 42,
page 42.
page 43, my lord, Annex 30.
Where is the order of attachment? This is what I'm trying to ask you from the beginning.
They have asked me to withhold, my lord. They have used the word withhold.
The page number? Which page you said is the impugn order?
Impugn order starts at page 43, my lord.
43.
relevant part starts from para 5 at page 45.
Page 45. Page 50, para 14. The deponent for the state. Who is this deponent? Because para 13, judgment debtor so and so. Para 15, judgment debtor has stated. Para 14, deponent has stated. Who is this deponent? Is a
Most
judgment
probably it
debtor or
will be
somebody
the-
else?
Most probably it will be the decree holder, my lord.
Decree holder.
Most probably it appears because they have approached the
No, just
Honorable
a
Supreme
minute.
Court, my
So
lord.
decree holder. Where is the order dated 1/10/2022? That first order that
Yes,
I
my
read,
lord, which I pointed out.
page number
Page number 22.
22. Your name?
D. Goswami.
Heard Mr. D. Goswami, Law and Counsel for the appellant. The respondent number one, MS Billwood Private Limited, is a decree holder. And the respondent number two, MS Bharat Heavy Electrical Limited, is a judgment debtor in respect of an award, arbitration award.
Yeah.
Dated But what is wrong with this order? Why is the NTPC on appeal?
Yes, my lord. My lord, when,
See, your only stand you have taken somewhere is that the contract may suffer.
no, I had filed another objection, my lord. There was another objection which was filed on 19th of August 2023, on the date of the order, my lord. That was not taken into consideration.
What is that a petition?
In that, I had taken a stand that to make to order an attachment for on a garnishee, it has to be an admitted amount.
This is what the
debt
first,
has to be admitted, my lord.
Mr. Goswami, this is the first question I asked you.
Yes,
In the
my lord.
very beginning of the proceeding, this is the first question
Yes,
I
yes,
asked you, but you did not answer that question at that
I
stage.
disputed. This is not an admitted debt, my lord. And therefore, when there is a dispute raised,
Now you are in terms,
Yeah.
and that's why I told you, that's
Yeah,
in the
yeah.
beginning I asked you this question,
No,
but
no.
for some reason you did not
well,
answer.
most probably I couldn't follow your logic now. Well, when there is a dispute raised,
Understand,
my
you
lord,
don't have to explain.
Yeah.
No. কি করলো? Is a judgment data in respect of a money decree amounting to rupees, a arbitration award date
yes, sir.
and money decree.
Arbitration award date is not here, my lord. Amount decree is, principal amount is 30 lakhs 94,000
30,94,
002
002
.00
with interest of
with interest of 12% per annum
per annum from the date of the
from the date from 24/01/2001.
to be payable from 24/1/2001. for execution of the money decree in favor of the decree holder. Money execution case number 29, 2015 had been instituted in the court of the, which court?
Learned District Judge Kokrajhar.
Learned District Judge Kokrajhar. Who made the application under order 2146, the judgment debtor?
Yeah, no, the decree holder made the application under, was because it was the decree holder who was to.
Understand? No, who made the application under 2643?
2146.
2143.
It was a decree holder,
Decree holder.
respond number 1.
In course of the money execution proceeding, the decree, the judgment, who made? Decree holder
Decree
made.
holder.
The decree holder made an application under order 21 rule 46 of the CPC for attachment of certain immovable property not in the possession of the judgment debtor. By making a claim that the judgment debtor has a contract agreement with the appellant NTPCL Bongaigaon, NTPCL Bongaigaon Thermal Power Station, and in course of such contract agreement, the appellant NTPCL Bongaigaon Thermal Power Station is sentence.
Decree holder made an application under order 51 rule of the for attachment of certain immovable property not in a position of the judgment debtor. The making claim that the judgment debtor is has a contract agreement with the applicant NTPCL Bongaigaon Thermal Power Station, and in course of the contract agreement, the applicant NTPCL Bongaigaon
Baba is in the possession of certain movable property amounting to rupees so and so, which they are liable to pay to the judgment debtor. While entertaining such the petition under order 21 rule 46, the learned district judge passed the order dated 1/10/2022, whereby there is a direction to the NTPCL Bongaigaon Thermal Power Station to withhold an amount of rupees 75,41,058 from the total dues payable to the judgment debtor until further orders. The appellate NTPCL Bongaigaon, NTPCL like Bongaigaon na lagi. The appellate NTPCL, which petition was filed by NTPCL? Petition number?
Petition number was 943 of 2020.
Filed petition number 943.
Yeah.
But that was not considered. In the order dated 19 943 is not considered.
943 was considered.
Well,
My,
no,
my petition number.
Huh.
Yes, I'm sorry, Miller. I thought.
after
It was,
entering
my
appearance
petition was 1029.
1029/2022
Yes.
for recalling the order dated 1/10/2022 by taking the stand that you don't owe that amount.
Yes. Miller,
Disputing the stand of the judgment debtor that immovable property amounting to rupees so and so is required to be paid by the appellant to the judgment debtor. Along with two other petitions, the said application number petition number 1029/2022 was given a consideration by the impugn order dated 19/8/2023. Being agreed by the order dated 19/8/2023, the present appeal is instituted by the appellant NTPCL. We have perused the order dated 19/8/2023. Full stop. But it is not discernible from the order that the learned district judge Kokrajhar had decided the question as to whether the appellant NTPCL owes an amount of rupees so and so to the judgment debtor. A condition precedent of issuing an order of attachment under order 21 rule 46 1 bracket C would be also to arrive at a decision that the movable property which is not in the possession of the judgment debtor is otherwise a movable property of the judgment debtor. Even the order dated 1/10/2022 based upon by which an amount of rupees 75,41,058 was directed to be withheld from payment to the judgment debtor do not in any manner decides the issue as to whether the said amount is a movable property of the judgment debtor which is in possession of the appellant NTPCL. In view of the prima facie case made out, the orders dated 19/8/2023, amongst others, in petition number 1029/2022 and the order dated 1/10/2022 made in petition number 941/2022 of the judgment debtor, of the decree holder under order 21 rule 43 under rule 46, it should be 46. It's 43, 41(3) or 46(1).
The order against the Garnisi, it's provided under order 21 rule 46B.
It has to be.
Yes. It has.
No, but they write 941 is under order 21 rule 41(3). Come to base 22. (41)(3) is something different.
My lord, this is not the petition. My lord. My petition.
Forget about your petition. I'm
No,
asking
no, actually, what is
Mr.
creating the-
Goswami.
My lord, there is a
Mr.
confusion
Goswami.
because- yeah. Their petition
Mr.
is
Goswami.
931, my lord, not 941.
Mr. Goswami,
Yes.
we are seeking some clarification from you, but you have a habit of going on and on whatever you want to say. For the time being, we don't want to hear what you want to say.
Yes.
To help our order, we
Yes,
want a small information. Please provide that. What is the number of the petition by the decree holder?
931 of 2022.
931.
31.
Then in page 22, in the order of attachment, why
Lord.
is application number 941 referred then?
My lord, this is what I was trying to clarify to your lord. My lord, this order has been, this has been passed as a common order, taking two petitions, my lord. 941 is some direction.
Okay,
To the
understood.
judgment debtor.
And petition number 931/2022. 41, right, 31, under order 41, rule 26. Read with one. We will complete.
Subjoin petition number 162 in the order of 1 maintaining petition number 952 2022 of the decree holder under order 121 to 46.
Shall remain state until further orders.
The date of the award was 7th of March 2006.
Item 14,
See, Mr. Goswami, if our input facts are not correct, somebody will go in appeal and again get it
Yes,
stayed for nothing.
No,
So therefore, we want some cooperation from you.
yes, madam. It's at page
Yes,
49.
next item.
madam. You got it.
May it please, Your Honor.
Yes.
I am for the applicant, I have filed application for vacation of the exterior order. So kindly see my IA Millard,
Packaging the interim order.
my
Which is the interim order?
interim order Millard,
22/5/23, Lord.
22/5.
Order dated 22/5/2023.
22. Page Millard,
Where is the order dated 9/1/2023?
That order, Lord,
17,
will
actually, we want to make it annexure 4, page 15.
Page 15. Mr. Rashid, yes, where is the impugn order?
that is on page 42, Lord.
42. Who had filed the divorce suit? The husband.
Husband,
You appear for the husband.
Yes.
Please show you your distinct salary slip of the last month.
Lordship, that salary is being put in.
Get it.
I don't have writing. But Lordship, in the order, Lordship, it's stated, Lordship, reflect that 35,000 he is earning, Lordship.
No, you have stated. We want to see your salary slip.
That I have to collect. Lordship.
Anybody from the education department, they will know what salary is paid to a teacher.
I'm told that about 50,000, is the mutual Miller.
Anyway, suppose it is 35,000 also.
Yes.
How many wives are you maintaining?
Only single.
The petitioner is the only one. The opposite party here is the only one.
With child Miller.
Why don't you give us her more money out of 35?
Lordship, now the litigation.
See, the lady has to maintain the daughter. She has to maintain herself. You are a teacher. You get 35.
Yes.
If you divide this amount by 3 also, then 35 divided by 3 is how much? Hmm?
10,000 plus.
It comes to some 12,000 something.
Yes.
36 would have been 12,000.
12,000.
Mother is 12,000, daughter is 12,000, 24,000. You enjoy the rest 12,000 for yourself. So the court had given 20,000. What is wrong with that?
20,000 for the litigation cost, Lordship, and I am already paying Lordship 7,000.
No, the 7, that has been the. You pay another 8,000, that is the only 7,000.
I have to maintain Lordship, I am working.
So your parents are more important than your wife and children.
Lordship.
For the parents, you will give them a 5-star luxury, and for the wife and children, let them suffer.
They are aged person, Lordship, they are not able to earn Lordship, so I have to Lordship.
You have to,
maintain
but
Lordship.
how can you give a disproportionate share to the parents and almost negligible to the wife? That is also not justified. We are not asking that you don't maintain your parents, but in the guise of maintaining their parents, that doesn't mean you the lion's share of your salary, you'll give it to them, and your wife and the daughter, let them suffer.
Lordship, I have
How can you accept that submission?
Lordship, I am paying that 7,000. I leave it to Lordship, but Lordship thinks is the litigation cost 20,000, Lordship, too much, and then Lordship.
Okay, litigation cost, it is you who have filed the divorce suit.
Because she has left me, Lord.
Maybe it is
They
you
let
who have.
me-
Litigation cost is given for the wife to come and attend to the divorce suit filed by you.
Yes, Lordship, but prior to that, Lordship, she has lost the Lordship DV case in Morigaon, Lordship.
She had done the right thing.
Their Lordship, that matter, Lordship.
No, must have done the most right thing by lodging the
Yes.
DV case against this man.
Yes, Lord.
So DV has ordered 7,000
7,000.
and the section 24 of the maintenance pendant light, another 8,000.
Yes, Lord.
What is wrong with that order? What is wrong with that order to continue with a stay order?
Lordship, she has left, Lordship, without any reasonable ground, Lordship. I have made.
Doesn't matter. In that case, the divorce suit will decide that. How can we take note of it? It's only an allegation at this stage. When the divorce suit will be heard, the real reasons will come out.
It's too expensive for this petitioner, Lordship, to bear, Lordship.
So for a man getting salary and also having some other source of income,
No, Lordship, I have.
forget
no
about the
other-
other source. Man
No other-
getting a salary, for him it is expensive. But for the wife, it is not expensive to come from one place to another place to attend the suit filed by you.
Lordship, she has left the house, Lordship, without any reasonable.
You are
ground, Lordship.
repeating for the third time. That is still in the stage of an allegation. It is not established whether he had left or you had left. It is yet to be established. That will be established only when the divorce suit is completed.
I am ready to go Miller to his house.
He is ready to go also.
To that time.
Our experience shows when there is another person in the life of a man, this kind of things happens. Because the new lady, your mind says, I should give the new lady something more than the old lady.
That was not anywhere, Lordship. at
It
least
may
by
not be.
the- by
But
our-
background, I use the expression, our experience shows. After dealing with hundreds of such matters, and after a lot of detailed deliberation with the parties, it's always that issue that comes up.
I leave it to Lordship regarding
Pay 8,000,
anything.
2 persons. How old is the daughter?
9 years.
9 years. She has to go to school now. Her
I have get her admitted in my place, lordship. She has late because
No,
of
no,
that.
she is ready to come.
I'm again, yeah,
She is ready to come.
yes,
See, moment she is ready to come, you accept her, we'll recall this order of 8,000. Because the divorce suit will become infructuous.
Yes,
Regarding the DV case, that is another matter. In a DV case, there is a concept called economic offense. Even if the husband and wife are staying together, still there may be economic offense.
I leave it.
You don't leave it to us, leave it to yourself.
Leave it.
Heard Mr.
B. Chaudhary.
B. Chaudhary and counsel for the petitioner, also heard Mr. For the petitioner husband, and now Mr. A. Rashid for the respondent wife. The petitioner wife instituted DV case being case number CR bracket DV 2421 in the court of the additional Chief Judicial Magistrate Morrigaon, wherein there is an order to pay an amount of rupees 7,000 per month. A divorce suit had been instituted by the petitioner wife, no, respondent wife, petitioner husband. A divorce suit had been instituted by the petitioner husband. In which court?
Is before the lordship. It is before the district judge Baksa Mosalpur.
In the court of the learned district judge Baksa. Inasmuch as the petitioner husband resides in Baksa, whereas the respondent wife resides in Morrigaon. In the divorce proceeding, an application has been filed by the respondent wife under section 24 of the Hindu Marriage Act, claiming for maintenance pendant light, which was registered as Ms. J case 8008/2022, wherein an order dated 9/1/2023 had been passed, requiring the petitioner husband to pay an amount of rupees 20,000 as litigation cost to the respondent wife to attend the divorce proceeding at Baksa, and a further maintenance pendant light of rupees 8,000 per month in addition to the 7,000 already ordered to be paid for maintenance of the respondent wife and the minor daughter, including her educational expenses. Being agreed by the order dated 9/1/2023, this present revision petition has been instituted, wherein there is an interim order dated 7/3/2023, by which the order dated 9/1/2023 had been stayed. 2023 in May 8, 2022 had been stayed. The respondent wife institutes the present interlocutory application 1700/2023 for vacating the interim order dated 17/3/2023. Mr. B. Chaudhary, learned counsel for the petitioner husband, takes the stand that the petitioner is a school teacher and he has a monthly, and gets a monthly salary of rupees 35,000 per month. After the same, he is also required to maintain his two aged parents. And therefore, according to the petitioner husband, 7,000 per month for the wife and the minor child would be sufficient. Full stop. Even if we take a proportionate amount of the salary of rupees 35,000 for 5 persons, being the petitioner himself, the two aged parents, and the wife and the minor child, still the share per person would come to rupees 7,000, meaning their wife, for the wife and the child, it would come to about 40,000. If 7,000 per month plus an additional maintenance pendant light of 8,000 per month is granted against the petitioner, the same does not appear to be disproportionate or illegal in any manner. Full stop. Mr. A. Rashid, learned counsel for the petitioner, Mr. B. Chaudhary, learned counsel for the petitioner husband, states that the respondent wife had left his company on her own volition without any acceptable reason. And on the other hand, Mr. A. Rashid, learned counsel for the respondent wife, states that she is willing and to go back to her, to the petitioner husband and continue with their married life. In view of the statement of the respondent wife, comma, it will be in the, comma, we are of the view that it will be interest of both the parties if the respondent wife goes back and continues her married life with the petitioner husband. Accordingly, as per the statement before the respondent wife before the court, she is directed to go and stay. She is required to go and stay with the husband, stay with the petitioner husband. As a conclusion had already been arrived that maintenance of rupees 7,000 per month plus 8,000 per month would not be highly disproportionate, considering the salary received, salary of the petitioner husband. We have the view that we see no merit in this. We see no merit in this revision petition. Accordingly, the same stands dismissed. But however, as agreed before the court, if the respondent wife goes back to the husband and continues with the marital life, the maintenance of 8,000 per month shall not be required to be paid by the petitioner. As regards the 7,000 already ordered in the domestic violence matter, we leave it to the parties as regards the amount of rupees 7,000 per month.
I am ready, but if he
I have to take instruction.
In the event the respondent wife agrees and goes back to the petitioner husband, but it is he who is not willing to take her back, the maintenance of further maintenance rupees 8,000 shall be continued.
Just regarding litigation, is of 20,000.
The litigation, we are not interfering. That cost she will need to come from Morigaon to go to Buxa to stay with you.
But here 20,000 has been directed.
Understand? She'll need that money to travel from Morigaon to Buxa, taxi fare.
20,000.
Or you want to go in some local bus? First trip from Morigaon to Zagi Road, then Zagi Road to Guwahati, from Guwahati to so and so. You want to travel your wife in that manner? Give them some dignity.
Litigation cost 20,000.
We will increase it. We are thinking of increasing it. 20,000 per one time is a too less an amount. Every day she will have to go to Buxa. She needs more, in fact. As regards the litigation cost of 20,000, we modify the same and provide that the petitioner husband shall pay the respondent wife an appropriate amount on every date she is required to attend the court at Buxa, including the expenses of a guardian to accompany her plus lodging arrangement at Buxa for 2 nights which will be quantified as per the actual cost and shall also include the transportation cost from Morigaon to Buxar
Highly appreciated.
in a reasonably acceptable manner of transportation.
Highly appreciated.
If you are willing, take back your wife. It will be much more easier for you.
Better.
And forget your differences, sort it out. Or go for mediation somewhere. Somebody will sort it out.
All right.
You want the modification or want to retain 20,000?
I leave it to you.
It is almost impossible to find out any substantial question of law. Very rarely you get one substantial question of law. How can you get 4 substantial questions of law? Substantial question law is not a ground. There is a difference between a ground and a substantial question of law. These are basically grounds.
Question is this, wrong reading, misreading,
Of,
or non-reading of evidence
not evidence, of a document.
of a document,
Hmm.
yes.
Oral
Now-
evidence, no. Document, yes.
Misreading and wrong reading is also a substantial question.
I know. But
So,
evidence relating to documentary evidence.
yes, documents they
Suppose one-
themselves say,
Suppose one cell lead is there, it is wrongly read, it's a substantial question.
first thing, I have
But-
formulated 4,
But your first ground is
that
on
that
oral
does not
evidence.
mean 4 shall not may accept to,
No, no. We have to formulate a question. So we are seeking your help in that.
now, Lordship,
These, we cannot write all these substantial questions of law.
the question
Now,
is,
what happened? Tell me. Where is the dispute?
dispute is this, my lord, we have raised some right title interest of our plot of land.
You are the plaintiff.
We are the plaintiff
Huh.
appellant.
Hmm.
We have claimed some plot of land
Right title.
as our right title interest being the son of late Naimuddin, who was the original owner. Now they say that we have purchased this plot of,
They have purchased the plot of land.
that is they say.
Ah.
But they could not produce any, they have purchased the land 58 years back.
Ah.
58 years back, they have purchased from our forefather, that is Naimuddin.
What is their evidence regarding purchase?
That they say, since the
Where is the WS?
WS, that lordship may
Where
kindly
is the
say,
statement they have
page
purchased?
29,
Which statement they say they have purchased?
page 29 maybe, see.
Submit that the lifetime of the father of it.
That may be seen page 30, para 11.
He sold land. Did they exhibit any registered sale deed by which father of plaintiff one sold 2 acres of land to Jafaruddin?
They have exhibited sale deed,
They exhibited some
but we
sale.
have said that this is false deed, that should be cancelled. That was
Your
also our
stand
claim.
is that sale deed is,
Falsely
False.
executed fraudulently, by fraudulent means.
it's a fraudulent sale.
Yes. Now,
Now, what is the finding of the courts on that stand of fraudulent sale?
the court has said that as the state was not challenged earlier, so that is not accepted. But most
Please come to that particular finding of the trial court.
that lordship may kindly see page 74 lordship for a moment. And wait,
Page 70.
page 74 here is only very important substantial question of law, page 74. Kindly see
No,
bottom.
please take me to the finding of the trial court that finding of the trial court that the sale deed was not challenged earlier, therefore you cannot take that stand.
That is page 78, lordship. It is from page 78, but the concluding standard lordship would say page 79, the second part.
Hmm.
In the final question, which is exhibited in exhibit 1, it
Yeah.
is clear that Jafiruddin Ahmed had purchased 2 acres.
What is exhibit 1?
my lord.
What is exhibit one?
Exhibit one is the cell deed.
No, but they use the word Khatian.
So Khatian, Khatian.
No,
means-
there is a difference
No,
between a
that is
sale deed
totally
and a
different.
Khatian.
The Khatian.
So
they
exhibit one
exhibited-
is a Khatian or it is a sale deed?
The Khatian they have shown. They have shown Khatian, and from that Khatian they have purchased the
No,
land.
what is a Khatian?
Lord.
What is a Khatian?
Khatian is the record of rights normally
Record of
prepared.
right. This is what we are asking you.
Yes.
Exhibit one is a Khatian.
Khatian.
Have they produced a sale deed?
Their so far their cell deed is concerned, my lord. Lordship may kindly see page 88.
No, no.
Page
Mr.
88.
Mahmood, if you respond to my question, it will be of bigger help for you.
Yes.
In the written statement, they say that they are owner of the land by virtue of a sale deed. This is the stand in the written statement.
Yes.
So, burden of proof is on the defendants to prove that they are the owner of the land by virtue of a sale deed. So, and your stand is that the sale deed is a fraudulent document.
Fraudulent.
Very well. Now, therefore, I'm asking you, where is the decision by the trial court on the stand of right being claimed on the basis of a sale deed and your stand that it is a fraudulent sale deed? Please point out that. If you point out, I will frame the question of law on that issue.
That question Lordship would get here. The learned court granted the right.
Or else you will compel me to read the whole judgment. It will take another half
No,
an
no,
hour.
I
Please
am.
point out the
They
relevant.
have not claimed. They are saying we have no claim over 4 bighas of land. But that is also given to them.
Mahmood, please come to page 30.
Best 30 years.
Para 11.
11.
Defendants submit that during the lifetime of father of 91 to 3, he sold land measuring 2 bigha to Jafaruddin, father of defendant.
Yes.
In 65, by a registered sale deed.
Yes.
So, the claim of the defendants regarding the disputed land is by ownership through a sale deed.
Yes.
So, burden of proof is on the defendants to prove their own case. You say that they had exhibited the sale deed as exhibit number.
As exhibit number A, B, C, D, page 88. A, B, C, D, several times E.
Fine.
So,
So now, and your stand is these sale deeds are fraudulent.
fraudulent.
In which paragraph trial court has decided this issue?
That may be seen, my lord. Page 84,
84.
onward. 84 and 85. From the evidence record, it appears that Zahiruddin Ahmed, alias Zafiruddin Sheikh, and Rabia Khatun Bibia jointly have right, title interest to the extent of 3 bigha of land under tag number 139, petition number 58. Plaintiffs are also in their evidence have stated they have filed the suit for 4 bigha 10 lessa of land in tag number 139. They are silent about the land in tag number 143.
Mr. M.U. Mahmood and counsel for the appellate. Admit. Return over 6 weeks. For the report of data that should. Where is the plaint?
Plain. Plain must be page 11.
11. The appearance instituted suit 5/2017. claiming right title and interest over the scheduled suit land who is Jafaruddin,
Jafaruddin is their
father of the plaintiff,
defendant father.
defendant's father. According to the plaintiffs, their predecessor in interest, Naimuddin Sheikh, according to the plaintiffs, as per para 6 of the plaint, their predecessor in interest, Naimuddin Sheikh, held and possessed a plot of land measuring 5 bighas 0 kotha 16 lessons of bag number 139 and 143 under Khatian number 58. And he possessed the same till his death, and after his death, the present plaintiff appellants had inherited the same. The defendants in their written statement in paragraph 11 takes the stand that the order of the plaintiffs number 1, 2, and 3 during his lifetime had sold 2 bighas from dag number 139 to Jafaruddin Ahmed, being the father of the defendants number 1 to 5 in the year 1965 by a registered sale deed. And later, in the year 1974, Naimuddin Sheikh again sold 3 kotha 15 lessons of land from the same dag to Rabia Khatun by a registered sale deed. Reading of the respective stands in the plaint and the written statement, it's discernible that it is the claim of the plaintiffs that their predecessor in interest, Naimuddin Sheikh, held and possessed a plot of land, a plot of land of 5 bighas 0 kotha 16 lessons of dag number 139, 143 under Khatian number 58, Tozi number 1 of village Boruapara under Kokrajhar Revenue Circle. Whereas it is the claim of the defendants that a part of the land had been sold by the predecessor in interest of the plaintiffs to the predecessor in interest of the defendants by respective registered sale deeds. While deciding the issue number 7, the learned trial court took note that the name of predecessor in interest of the defendants, namely Jafaruddin, appeared in the Khatian number 58, and therefore the right title and interest of the plaintiff, and therefore the right title and interest claimed by the plaintiffs were rejected. No mention is made in the judgment regarding exhibition of the registered sale deeds by the defendants with reference to their stand in para 11 of the plaint that their predecessor in interest had acquired the right title interest by virtue of the sale deeds. In the aforesaid circumstance, a substantial question of law is framed as to whether, in view of the statements in paragraph 11 of the plaint, the burden of proof regarding the right title and interest over the suit land by the defendants had shifted to them to be discharged by producing the relevant sale deeds, which are claim to be the instruments to which their predecessor and interest had acquired the right title and interest. And corollary substantial question of law as to whether any such relevant sale deeds were exhibited and examined by the court below before declining the right title and interest of the plaintiffs. Call for the record. The judgment statements shall remain present for the orders.
Other substances may be raised if so desired, appropriate time.
That is always there.
Another substance one legal question.
Mr. Mahmood, we don't have to quote
No, I
that
understand
Mr. Mahmood is entitled to approach this
Yes.
court in any other matter if it is listed.
Section, as per section 50, my lord, within 6 months, petition has to be, but they, 58 years they have not done.
16 and 17 for orders.
Can urge upon it. Why was it 13 part, Mr. Biswas?
Lordship, it was a case with regard to
65C, where I think one certified copy had been produced.
our contention is their contention is that the learned trial court below as well as the first appellate court did not consider the secondary evidence which they had produced through the certified copy of the sale deed. Our contention was that the sale deeds are fraud and that point.
Sale deeds are fraud.
Yes, it was fraud.
You are the plaintiff or defendant?
Partner, Lordship.
Miss, you are appearing for the plaintiff or defendant?
I am for the plaintiff
Plaintiff.
because their
So,
counterclaim.
in counterclaim, they take a stand that they establish their right by virtue of a certified
sale
copy of a sale deed.
Court sale deed.
And your stand against that is that these sale deeds are fraud.
Yeah.
From where do I get your stand of fraud?
Your Lordship will come, if the
Page
Lordship
number.
comes through our plain first of all, with the WS to their counterclaim.
Where is it? Page number. And here, who is the appellant? Your client or he is the appellant?
Because
Understand.
it was in our table. Now, your Lordship,
What is the stand of fraud?
the WS by the plaintiff, your Lordship will come at page 51 of the memo of appeal. Your Lordship.
Page 51. Page 51 is the name of the parties in some death.
No, sorry, of their memo of appeal. Page 51 of their. Of RSA 58. This is the WS which we filed against their counterclaim.
Hmm.
Now,
Where is the name of?
page para 21 at page 54. It starts from page para 21, your Lordship. At the, if I may read out it. From the bottom of para 21, it is not true and denied. This is one stand with one. There are 4 sale deeds. For each sale deed, we have given a specific denial. Your Lordship. Para 21, 22, 23, and 24.
This
And
not a-
there are part-
this is not a stand of fraud.
And para 29 year old, specifically fraud. Para 29 at page 56. Fraudulent and collusive.
Fraudulent. Was any issue framed on
Issue-
on stand of fraud?
No, not on fraud, but general issue was framed with regard to the right claim over the defendants over the suit on the basis of the sale deed. Issue number 7, 8. and-
See, the sale deeds were rejected by referring to section 65 or something of the evidence, Act, 65 or 67.
Your Lordship was.
But your stand is there fraud.
Yes, that is a specific.
Once it is a fraud, there has to be an issue whether these sale deeds are fraud.
Yeah.
And then he will establish his case that it is not fraud, and you will establish your case that it is fraud.
Yeah.
Okay, this is how ordinarily it should have proceeded. But the court, instead of deciding an issue of fraud, framing an issue on fraud, merely brushed aside the sale deeds, saying that section 65 had not been satisfied. So now let us come to section 65. What is 65? 65 or 67? 65. I think. 65. What is 65?
Evidence of.
Cases in which secondary evidence relating to documents may be given.
Because their contention is they could not produce the original because it was robbed from them while they were bringing the original to some other case. While
No, this is a good explanation. So secondary evidence is admissible when an explanation is given why the primary evidence cannot be produced. Once this explanation is given, secondary evidence is a.
the foundation is laid and that can be.
Once it is a secondary evidence rendered by virtue of a certified copy.
Yes.
Certified copy is section 74.
74,
I think.
Your lordship, 79, your lordship had taken on the last. occasion.
Understand. First, it will come to 76, certified copy,
Yes, of public document.
public document. Public document is 74. 74(2) is public records kept in any state of private documents. So normally these are private documents, but as they are registered documents, they are also kept as public records. So this is a public document. So of this public document, law entitles them to procure a certified copy. Certified copy is section 76. 79 is presumption as regards genuineness of a certified copy. So moment they have produced a certified copy, there is a presumption of law in their favor vis-a-vis their explanation that the original had been lost somewhere. You can do two things. You can either question their stand regarding the original being lost. This is number one.
That we have done.
Or else there is a presumption in favor of genuineness of a certified copy, but you can challenge it saying that the deed itself is fraudulent. Certified copy is not fraudulent. The deed is fraudulent.
Deed itself is fraudulent.
That deed itself is fraudulent. Once you take the stand that the deed is fraudulent, the burden of proof is on the party alleging that it is fraudulent.
That is true.
It's on your
It
client.
is my duty to establish.
So, in our view, this ought to have been an issue before the court.
With regard to the fraudulent aspect of it.
More particularly with regard to your stand in page 56 of the memo of appeal.
That specific stand of para.
And he will prove it and he'll disprove it.
And
So until and unless this is done, his claim can never be decided in the appropriate manner. His claim cannot be decided by saying that you failed to testify the vendors of the sale deed, therefore I am not accepting.
because
This is where we are having a little difficulty in accepting. I know most of the civil courts are taking that stand, taking that view, but it appears to be a little incorrect. Otherwise, the evidentiary value of a registered document and evidentiary value of a certified copy will be nullified if the vendor has to come forward to prove the execution of every document.
there is.
And this is, in fact, a disturbing situation which is already happening. And this is the second or third matter I have found in course of these last 2 weeks. I don't know. I think this issue has to be taken up before the Judicial Academy also to inculcate this aspect before the civil judges, that once a registered document is produced, there is a presumption of law in favor of its genuineness. Once a certified copy is produced with the explanation of why the original is not available, there is a presumption regarding genuineness. But on both occasions, I have noticed that the courts are insisting, get hold of the vendor and prove the deed. This is not, firstly, not a requirement of law. And in many cases, it will be an impossibility. And if we accept this to be the position of law, we are inviting the land grabbers. All that the land grabber will have to do is, tomorrow you will be in trouble with your own private land. They'll have to occupy your land. He will file a suit for dispossession by claiming right title and interest. You will show a sale deed that this is my title, my father had purchased this. If your father is dead, you are finished. Because you can never bring your father for evidence to prove that one. So for this issue also has some public interest. Once a constitutional court accepts this to be the position of law, that even a registered sale deed or a certified copy of a sale deed where original is explained, the courts require the vendor to come and prove the contents of the sale deed. Dangerous situation.
Okay, sir. You're-
Today, for your case, you may defend vehemently, I understand, because you are holding the brief of a client. We are putting the question from the
that is
public
true, yeah.
importance point of view. And I have noticed,
No,
and
this
I
is-
see no reason regarding registered judgment. We already delivered a judgment the other day, Mr. S.P. Roy's case.
Yes, I will.
Regarding certified copy, only one addition is there. If the non-availability of the original is explained. In
That is
that
the
case,
question out here.
so you had twofold remedy available. One, you challenge the stand of non-availability.
That we had done, we cross-examined them.
So you have to prove it.
They could not.
But
produce-
where is the issue?
That was discussed in the issue, you know.
Where?
I'll just draw your lordship's attention with regard to these points.
So in that, if the non-availability is duly explained, it will not be a case of 65 or 67 to examine the vendor.
Yes.
But it will be a case to reject a certified copy. But we are a little perturbed with vendors regarding to prove a sale deed.
Yes, sir.
Many of people must be sitting here. The land they are occupying must have been purchased by their father. Many of them may be their father is no more. If the law requires the father to come back from heaven and prove a sale deed, what will happen to their respective lands? Tell me that.
That is true, your lordship. But if
Is it
I,
not a serious issue?
now, lordship, the trial court, first of all.
Where is the finding on his stand that the
Issues number 7, 8, and 9
page
at
number?
page 71. This is the trial court judgment.
No, specifically the finding that his stand of the original being not available is
That is, I'm coming here.
wrong. Only on that one.
Yes. Para 29, page 75, I think. your lordship.
Is 75, para 29.
In the case in hand, if I may read out.
Just. So court should have called for the records of the relevant police case in
They
Rohtak.
have not mentioned anywhere with regard to the no pleadings.
Mr. What is the Rohtak case number? Regarding your allegation of
This case number is not mentioned in the report.
not mentioned, find out.
Not mentioned.
If necessary, we'll call for that record. Don't worry.
Yes, that can be convinced. They did not mention anywhere. We
Appellate court can
made
take
a query
additional
also in the cross-examination. They failed to substantiate this.
The You are for the appellant.
Lord,
The appellants to inform the court as regards the Rota Police Station case number regarding the FIR lodged by the defendants regarding the sale deed number 3621/2018. The 3621 dated 8/11/2017. Sale deed 811 dated 18/2/2018. Sale deed 226 dated 22/12/1983. And sale deed 2260 dated 22/12/1983. It is, he does 75, what does it? At gunpoint by two unknown persons. Because this will lead to some presumption on the truth. If it is not there, it's a false.
This is a false statement on affidavit.
And I think we can call for additional evidence. There is no bar under the law. The appellant to also apply for a certified copy of the entry in the register maintained by the sub-registrar, maintained by the registering authority, where the aforesaid sale deeds were registered. Get a certified copy of the register. The sale deed will be entered if it is there. Please call next week. Next week.
2 weeks.
No. Next week. If you have, you can get it in 1 day also. If you don't have,
Lordship.
3 weeks also not help you.
Obliged. Item 18.
Here, I'm appearing on behalf of the respondent and the.
But Mr. Biswas, the other issue we are interested to go into. The issue of vendors being required to come and depose. I think we are having some reservation on that. And it has attained a more dangerous proportion because it is followed almost everywhere. And I see no reason why registered or.
That has to be settled because very contradictory
It's being,
plans are coming.
it's being done regularly on a regulation basis. It's done.
But there is a judgment of the Madhya Pradesh Division Bench of the Madhya Pradesh High Court, which says that sale deed are not registered document, a public document. That is there.
Why not?
I don't know, means that is.
Madhya Pradesh saying will
No,
not
I'm
take
just-
away section, I think 74 2 will not be taken away by Madhya Pradesh.
79 clearly,
74 2 says what is a public document?
that is,
A private document in the custody of a public authority is also a public document. So sale deed is a private document, but in the custody of the
once it is entered in the register,
registry,
it becomes-
it becomes a public document.
that has to be settled.
It has to be settled.
Various contradictory judgments are.
Otherwise, dangerous situation, I'm telling you. You are opening the gate for the illegal activities. Many of you may lose your land because of that tomorrow.
Apex
Next
court
thing-
judgment is, latest judgment is there, Lordship, in this regard.
That
What?
is the apex of it.
What,
Apex,
on what point?
regarding public document, Lord. Paragraph 20,
Paragraph 20,
20. And Lordship, paragraph
20.
21, 22.
21, 22. It's it. Takes note of 74 2, makes the
Yes,
public
no, no,
records kept in
74,
any state
section
of private
74
documents is a
subsection
public document. Supreme Court has accepted that.
Accepted.
But so far, I think people, I've not gone through the judgment, but here there was no objection raised with regard to the. But deciding this, particular.
But we follow Supreme Court, we don't follow Madhya Pradesh, number one. And Madhya Pradesh, we have some grave doubts. On a plain reading of 74-2, we are unable, not persuaded. Another High Court judgment is only persuasive, we are not at all persuaded.
But due respect, this judgment, your lordship, there is a para which gives that the documents which was taken into consideration by the ethics court, there was no objection raised by the other side while exhibiting this.
See. Again, burden of proof. Objection has to be proved. Objection is not merely to be raised. There is no law that I raise an objection, now it is for you to go and prove your case. If I raise an objection, it is my burden to prove my objection. Same thing.
The secondary, because the burden, the ethics court said that the original, once the objection is raised, by the original.
So do you mean to say that anybody relying on any certified copy, all is that is required is one word, I object. And everything else falls through. I don't think so.
Understand.
If you object, you'll also have to say why you are objecting it. And prove your case.
The next.
Otherwise, one word object in every written statement, every affidavit in opposition, right object. So moment object, one word object is written, every case has to be dismissed. If that is the law. Objection also has to be proved.
The next.
But you also act as an amicus in this matter because it's a little important question. Apart from settling your respective legal claims, what this issue?
Item 18,
Yes, ma'am.
Yes, Your Lordship. Your Lordship, I am appearing on behalf of the respondent side and on the earlier order dated 28/9/2023, it reflects that the learned counsel for senior counsel has appraised his honorable court that the appellant's advocate has expired and they have not appeared, and for non-appearance, so further notice has been issued by this honorable court, and the registry has taken the steps, and by the office note dated 10/11/2023, it has been stated that they for due to
Just a
insufficient.
minute. Why should you not dismiss it for non-prosecution?
As your lordship may-
No. Where is the law requiring the court to issue notice if somebody does not appear for 10 years? But none appears for the appellants when the matter is called. It is noticed that when the matter was listed on 24/9/2019, none appeared. On 21/10/2019, there is no representation by the appellant. On 22/10/2019, adjournment was sought for by the respondents. On 28/9/2023, again, none appeared for the appellants. HP Burman, I think HP Burman died. No. Aged man is nothing than HP Burman. Mr. Roshi, do you remember HP Burman? I think old gentleman was there, right? HP Burman. He died. But on 28/9/2023, the court was informed by the respondents that there is a possibility that the learned counsel HP Burman may have died in the meantime. In the circumstance, there was a direction to issue notice to the appellants in the correct address. The office note dated 10/11/2023 provides that The notice had been issued in the correct address, but it has been returned back with a postal remark insufficient address. As the attempt to serve notice on the appellant did not succeed, and the learned counsel who had earlier appeared is also no more, and the appellants are not taking any proactive measures for representation before the court. The MFA 98/2013 stands dismissed for non-prosecution, however, with liberty to the appellant to file appropriate application if so advised. Now, Nabdul appears for the default.
Item 19,
Day he wakes up, let him come, we'll revive it. And also considering this to be a matter of the year 2013, when persistently there is no representation from the appellant. Then to what the, yes,
May I please, your lordship? Lordship, LCR have been received, it may be picked up for hearing.
not today. Stated that the LCR has been received and the matter be taken up for hearing, pray aloud, list accordingly.
item 20,
Where is your lordship? Official dated 27/10/23,
Mhm.
LCR of TS num C25/2010 has been received, but LCR number TA num 8/2014 has
Sorry,
not received.
please go a little slow. It's on service.
Sorry.
Which office note?
Official 27/10/2020,
27,
10,
10, 2000.
23.
Issue reminder for the LCR of TA 08/2014 from the court of the. Which court? No, which court? Civil judge or district judge or
Civil judge Borpeta.
civil judge Borpeta. With reference to the office note dated 27/10/2023.
Lordship, I pray for an appeal memo from there.
That prayer has to be made that side, not this side. You make the prayer to Mr. Ahmed.
21,
Mr. Ahmed. Give the copies that they can respond.
Okay.
Union of India represented by General Manager NFA. Yes.
Here, in this petition, a confidential petition has been filed.
LA appeal 2017 IA. Why is the IA being filed?
It's for continuing the delay of 828 days,
828
28 days.
delay.
Yes, yes,
Notice was issued.
yes, yes.
No, somebody.
And
appeared.
yes, they have filed.
The
also.
private respondent 2 weeks time. Who appears for the private respondent?
Unaware of this.
The railways filed the land acquisition appeal.
Lordship, yes, your lordship, we have filed the.
Land acquisition.
Yes.
And
we have
after
filed-
filing the appeal, you did not appear.
No, your lordship, we have appeared.
No, there is a order.
So we have filed, your lordship, is IA also together. An affidavit in opposition has also been filed by the respondent number 1 against the confidential petition.
Heard your name?
M. Chatterjee.
M. Chatterjee, Land Council for the applicant. ISC 2360/2017 has been instituted for condoning a delay of 828 days in filing the accompanying land acquisition appeal, which is yet to be numbered. Notice was issued to the sole respondent who had entered appearance to a learned counsel, namely Mr. R.K. Sahani. The learned counsel for the respondents sought for adjournments on 24/2018, 8/6/2018, Twenty-four 5/2019, and 9/9/2019. The office note of 6/8/2019 shows that an affidavit in opposition has been filed and is available on record. When the matter is called upon today for hearing the application for condoning the delay, none appears for the respondents to oppose the prayer for condonation. The ground for objection taken is that the condonation application had been filed without any acceptable cause, and that the appellants had willfully abstained themselves while in the proceeding before the Land Acquisition Appellate Court. What is the amount? What is the amount of compensation given? Have you paid the amount?
No, Your Honor. Here,
Hmm?
I have no instructions.
In the objection, it is also stated that the landowners whose land had been acquired are suffering as because the compensation amount had not been paid. We have noticed that it's a condonation application for petition of condoning a delay which is pending for 6 years since the year 2017. The appellants are directed to pay 50% of the awarded amount to be deposited before the registry, and upon such deposits being made, further consideration would be made as to whether the delay is to be condoned. Pay 50% registry deposit, then we'll hear it.
A hearing may be done by my senior, Your Honor.
Yes. No, first you pay, otherwise we are rejecting. 17 matter, but it's too long a time, 6 years. 6 years you have not paid the amount to the landowner. If any amount had already been paid, the same be informed to the court, and in such event, the order requiring 50% amount to be paid shall not is not required to be complied with. List cost next week.
Item 22.
22, what is it?
Yes,
Same.
here, the amount has been paid by the date. And the,
Oh, what is this IA for?
it is also for combination of delay, your lordship,
Delay of how?
702 days.
Uh-huh,
And here the amount has been paid by the
Paid.
railway.
it's okay.
And
And who appears for the respondents? Allowed to take fresh steps. You have taken fresh steps.
your lordship, this case has become infactual because the division amount has been paid and by the order that has been passed and the
No, matter will not become infactual. You can withdraw your appeal.
yes, your lordship, we can withdraw.
You want to withdraw your
my
appeal?
on as the amount has been paid and in other courts also, your lordship, on the court, the matter has been withdrawn by us. Or as.
You have,
Yes.
you have withdrawn where?
Yes, because the other, appeal that has been pending before the other courts, your lordship.
Sorry, that statement I didn't understand. Other courts means? M. Chatterjee, Learned Counsel appearing for the applicant, states that the awarded amount had already been sanctioned by the petitioner appellants. And it had already been paid.
Yes,
Paid
your-
or only sanctioned?
No, paid, your lordship.
And the same had been paid to the landowner respondents. In view of the above, the petitioner appellant railway authorities do not intend to pursue with this interlocutory application as well as the accompanying land acquisition appeal bearing filing number 286751/2016. Accordingly, the interlocutory, accordingly, IS Civil 3372/2017 is closed. And land acquisition appeal to a number to the finding number bearing finding number say be also not required to be registered and be consigned to the record.
Like,
23.
A copy of the communication dated 19/1/2023 from the DYCE/on/1/MLG NF Railway Maligaon is kept on record.
Yes.
This one we are keeping on record.
I'm the owner of the vehicle, that's phone number 2.
Service is already been completed, lordship, but
It's a appeal by the insurance.
Yes.
You appear for the owner.
Owner, that's
Who
phone number
appears
2.
for the claimant?
claimant also has appeared.
Who appears?
MS LD Saikia.
What is your stand? Some fraud is there?
Yes, got it.
What the policy is fraud?
No, lordship, regarding ZD entry,
Huh?
regarding ZD entry, lordship.
The entry is a fraud. This appeal by the insurance company is filed, amongst others, on a ground that GT entry number
97,
97
dated 10/8/2015.
10/8/2015 in which police station?
Paksa PTAD,
In Paksa,
PTAD.
No, no, police station.
District.
Baksa BTB is a district. Which police station?
Govardhana. Govardhana.
In Govardhana Police Station is a fraudulent entry, and the claim of the respondent claimant is based upon such fraudulent DD entry. Madam Fukon. As the appeal of the insurance company is based on an allegation that the claim is based upon a fraudulent DD entry, as recorded, indicated above, we request MSK Fukon, Learned Junior Advocate, to produce the records in original of GD entry number so and so of Govardhana Police Station for examination of the court. List on a copy of the order. A copy of the order as well as the memo, baby. Give it to them. List on.
When the last copy, the NC was not called for.
29.
You don't need the LCR. If it is a fraud, we'll take some other kind of action.
Item 24.
Yes.
Pursuant to the order dated,
Order.
27/3, the healthcare was the not of record.
No, it is already.
LCR received. Today it is here, I think.
Today, this is.
Matter will be raised for hearing.
Today.
No, yes.
No.
Some other.
It stated that the LCR is available and the matter can be heard, but today the land council for the parties are not ready for the hearing. List again.
25 and 26.
From our side also any date. You come forward whenever you want.
I look like.
Yes.
Dates may be fixed, otherwise how should?
List on.
For December.
I live it.
Yes, item 25, 26, what is to be done?
25, 26, mediation done on 11/10, but it was still much.
That the mediation could not take place. Mediation failed.
But
I will hear you.
my lord,
When do you want to be done?
I also, my lord, regarding my lord, restraining the opposite party to my lord, prohibiting that for permanent construction. Over that schedule, land. Lordship, we have filed objections. We say that we have not constructed any construction over the schedule B land. Schedule B land is subject to the rotation.
Mr. Bhagavati, we take note of your statement that you have not done any construction.
Yes,
And
Lord.
Tulsi,
My lord,
I think that statement before the court is good.
my lord.
If they have done, it will be a contempt.
Lordship. Let us go, my lord, to add on the-
No, why should we add one order after almost 5-6 years? Why should we add one more interim order? Your allegation construction, we take note of his statement, there is no construction. And if he is actually constructed, he is liable for contempt now.
Lordship.
IA number
2490.
249, IA 2493 Lekipora. This interlocutory application is instituted by the appellant,
No, no, my lord. Respondent plaintiff.
by the respondent plaintiff, alleging that the appellant defendants taking advantage of the pendency of the RSA is undertaking certain further construction over
Schedule B land.
Schedule B land. Mr.
BK Bhagavati.
B.K. Bhagavati, land counsel appearing for the respondent
Appellant defendants.
appellant defendants by filing objection has made a categorical statement that no further construction had been undertaken by the appellant respondents over the by the appellant defendants over the Schedule B land. Taking note of the said statement, I have closed. And giving liberty to the applicant to approach again if any material is available that the statement given to the court is incorrect on facts.
Main case, madam, it is fixed for hearing. So as usual, court, my lord. Oblige.
Item 27.
May please, your lordship.
27, what is we done?
Lordship, is IA has been filed for condonation of delay.
Notice issued.
Office not dated 11/2/2022. The result of this shows that notice was already served,
Notice served.
my lord, but ADC has expired in case of respondent number 1, 4, and 5. So I think my lord will have to file necessary application for continuing.
That's somebody died. It is noticed by the appellants that. When did you notice?
Lordship, today.
I mean, from the office note dated. Notice by the today, that is Iman, as it did too. From the office note dated 11/2/2022. The respondents number.
1, 4, and 5.
1, 4, and 5
They had
had died during the pendency of the appeal. And accordingly praised for an adjournment to take appropriate steps. Pray along.
Steps upon respondent 2, 3, 6, 7, and 8 already.
Sir. As per the office notes.
Same, 11/2/22.
That was what you mean, sir.
Okay.
You are opposing, not opposing.
No, sir.
Can you condone the delay? Were PK Bora.
No, my lord, I'm for airport authority.
No, your name, please.
Mr. ANI Hussain on behalf of Mr. Rakesh Dubey.
Your name is
ANI.
J.N.I. Hussain.
Yes.
And your name, please?
And Borwell.
N. Borwell. Heard Mr. J.N.I. Hussain and counsel for the applicant, also heard Mr. N. Borwell for the respondent. You are also there, as well as MSK Fukan for respondent 3 and Mr. J. Handik for respondent number 2. Respondent 1 kori thoi dibo. This interlocutory application is instituted by the Appellant Airport Authority of India for condoning the delay of 75 days in preferring the accompanying land acquisition appeal. We have perused the grounds taken in the application and also heard the counsel for the respondents who do not object to the delay being condoned. Being satisfied with the ground and in view of the non-objection by the respondents, the delay of 79 days in preferring the accompanying LA appeal is stands condoned. I allow register to register the accompanying LA appeal and list accordingly.
29.
Sorry. You want it now only?
No, petitioner copy.
But otherwise, once the appeal is listed, there's a possibility we may not admit. Once a copy is given to you, there's a presumption of admission. Why do you want the copy? Hmm. Suppose we don't admit the appeal, we are only condone the delay. We have heard you. For the regular appeal, we may not admit, we may dismiss also. If you once give me a copy.
29,
But by accepting copy, you are almost leading the court to admit the appeal. Just next item. 29,
Same.
same order. How
Yes,
many days delay?
In delay, 221.
221. Academic.
30,
30 also, 30 different. Yes, Mr. Dutta.
Except 7, Lordship, service completed. And
7, what do you want to do?
7, he is expired.
Died. He died, 7.
7.
You want to substitute?
Lordship, we have communicated that line.
Sorry.
He may not be necessary to substitute.
It's your decision.
Yeah.
You don't want to substitute.
Don't.
Then we have to delete.
Because
No, just a minute. You have already made him a respondent. Okay. Now the man dies. You feel substitution is not required. Then we'll have to make an observation that the appeal against that respondent has abated.
it is abated in effect.
So we can,
Yes.
we can record that statement.
Record.
And rest we proceed.
Yes.
Should we hear the appeal today?
No.
Not today. Okay. It is stated by Mr. U. Dotol and counsel for the appellant that the service of notice upon the respondents other than the respondent number 7 is complete. It is also stated that the respondent number 7 had died in the meantime, but there is no requirement to substitute the legal heirs of the respondent number 7. In view of such statement, appeal against respondent number 7 stands abated. LCR received? LCR is stated that the LCR has been received. List again for hearing of the matter.
31,
31 years.
May I play the first?
I for what purpose?
I have for substitution of respondent number 1 matter.
Respondent number 1 died.
Yes, right.
You want to substitute his legal heirs. When did he die?
That in 28/4/2007.
24
2007.
month. 24 is the date on in which month and which year? 28/4/2017 he died. When did you file the IA for substitution?
And this I
Hmm.
18/12/2007.
So 18?
12/2007.
No, you filed the IA on 4/2/2019. Your signature is also there. Gyasuddin Ahmed, advocate, 23/1/2019.
Actually, at first we filed the condemnation of delay petition.
Delay has been condoned.
No, my lord. In thereafter, the honorable court issued notice.
Mr. Counsel, you are aware of the law of substitution? Are you aware? If you don't file the,
Respond after appearing respond number 2, he informed that respond number 1 has been died. Thereafter, we filed this substitution along with abutment.
when did you come to know that the man died? On which date?
What happened, my lord?
Mr. Counsel, we are not interested in what happened. We have to look into whether before filing this application, the appeal has abated or it has not abated.
18/8/2017.
You came to know about the death on 18/8/2017 and he died on 28/4/2017.
Yes, sir.
if you don't substitute within 3 months, 3 months is the period, I think, Mr. Nath. 3 months of the date of knowledge of the debt, the appeal stands abated. In that case, you'll have to file an application for setting aside the abatement first.
Yes, sir, we have filed a.
Where is that application?
662.
Hmm? 662. And 661 is for condoning the delay.
Yes, sir.
Has notice been issued in the,
Consideration of deliberation.
has notice been issued?
Yes, sir.
Hmm? What is your name, Mr. Counsel? What is your name? Your name, apna naam to ki?
G.U. Ahmed.
G.U. Ahmed. You are always not ready with the proper facts, which will enable us to take a much faster decision what is to be done. Ultimately, you require us to look into everything and takes about 15-20 minutes for nothing. How can we help you if you don't help us? Has notice been issued in the application for condonation of delay? Please find out from the order sheet and tell us. It's not the duty of the court to do this clerical work and find out what is happened and what is not happened. And if notice has been issued, whether it is served or not. And if served, whether somebody is appearing or not. Please take note and tell us that.
32.
32 years. What is this IA for? IA filed by whom? MFA.
Lord, I am appearing for opposite party number 3, Lord.
Insurance. This is a motor accident claim.
Yes, Lord.
Accident claim.
Yes.
What is this IA for? 399?
For condonation of delay, my lord.
Condonation of delay.
118 days.
118 days in preferring the appeal. In preferring the appeal.
Yes, Lord.
Are you opposing?
I am not opposite.
Lord, this,
Are there any other respondents?
Service is not complete. As per office note dated 22/3/2020.
22-3?
23.
Neither AD card nor.
Lord, this matter.
Who is respondent number 1? Who is the owner?
I am the, I'm appellant.
I know you are appellant. You are yet to be appellant because appeal is yet to be not yet admitted. You are for the claimant or owner of the vehicle or
Claimant.
for the claimant. You are agreed by the quantum,
Yes, sir.
by the quantum. And who is respondent number 1?
One is the owner of the,
Owner of the vehicle. And who is respondent number 2?
who is the insurance.
Insurance has
Yes,
already
I
appeared.
can appear, Lord. Branch office.
You can appear.
Yes,
So this matter may be settled on local adalat.
yes, Lord. That can be
Why?
settled.
How can we settle in a local adalat when appeal is yet to be admitted? High Court local adalat we can send it local adalat only when the appeal is admitted, not before that.
Delay.
But for that, we have to condone the delay, get the appeal admitted, only then it will be referred to local adalat. But without service of notice on respondent number 1, very easy. Where does he reside? Any idea?
The owner.
Insurance company, you tell us the whereabout of your client.
Lordship, I can appear on behalf of respondent number 2, Lord.
No,
Number
to
2.
understand
I am
the
appearing.
owner of the vehicle.
Yes, Lord. He is residing, Miss Hasina Begum residing in Borpeta. They can take fresh steps, Lord.
Khoirabari, same village you reside.
Yes.
You don't know where does respondent number 2 reside, 1 resides.
As per claim application.
Sorry.
As per claim application matter, which was filed by the, before the Court below. They contested.
Mr.
the-
Council, how big is the village Khoirabari? How many people live in that village? Must be about 200 people. One villager is expected to know the other villager where they reside. Why don't you go and serve and come? Otherwise, it is you who is suffering. Hmm. It is stated that service on respondent number 1, namely MISS Hasina Begum, wife of late Aftab Hussain, resident of village Khoirabari, post office Khoirabari under police station Borpeta Road, has not been served. Petitioner to effect justice service on the said on the respondent number 1 through the registry of this court and thereafter file affidavit. It is noticed that the petitioner appellant is also a resident of village Khoirabari, is a resident of village Khoirabari, and the respondent number 1 is also a resident of the same village. Okay? Go and serve justice.
As well as registered post primary. Both.
Are you in a proper sense? It's a harsh question. We're bound to ask you, are you in a proper sense? You're taking 2-3 times steps on the same address. It is not served. Then we'll close this petition, dismiss your petition on being unable to serve then, if you don't help us. Mechanically, for the last 3-4 years, we are passing orders, take by registered step. You are unable to serve, so we have to find out a method other than registered step.
One time I have taken it. I've taken it.
Adjourn on the prayer of the petition. Next,
Item 33.
whatever you do.
Please second for it.
If you try to help people, they don't know how to accept help. What to do nowadays?
There's an IA matter
I for what?
for delay, donation of delay.
Service report on other respondents, it was.
You are appearing for?
I am for
For the state.
1, 2, 3, 4. And the respondent number 8,
Obhijit Bora.
1, 2, 3, 4 and 8. 1, 2, 3, 4, 5 and 8.
What
Eight.
kind of a suit was filed?
It was a suit for malicious prosecution claiming compensation.
Malicious prosecution.
And then
Who had maliciously prosecuted this man?
all the police officers have been implicated in the case.
Who had filed the FIR?
But I don't have the copy of the appeal memo. Only the condition petition has been given to me. The copies are not here. Possibly my friend has.
One was filed by my wife.
No, who had filed the FIR?
My lord, one SI,
Where is the
Pavitra
FIR?
Kolita.
FIR is at which page?
FIR unfortunately it's not here, my lord, with me because.
Can I
it's
take a
in-
look?
Yes, my lord. It's in the judgment, my lord, otherwise. Page number 37, though it's not registered, the regular first appeal, my lord. I can hand over a
Appeal is not registered, otherwise.
I can hand over the judgment, my lord.
Page number 37.
Page number 37, paragraph number 5, my lord, of the judgment.
Mm.
The plaintiff further stated that on 15/9/99, SI Pavitra Kolita of Behali PS lodged an FIR against the plaintiff under section 25 of the Armed Act. Then my wife also lodged an FIR, which my lord will find it.
FIR against whom?
Against the petition,
No.
the present applicant.
Against the
My wife, not against me.
No,
My wife has filed an FIR
against the policeman.
against the police officer.
And you have filed a claim for malicious prosecution, damage in thought.
Yes. ऐसा है करेगा सब
ऐसा मूवी देखो
ऐसा है तुम्हारे जैसे
वाइफ है पहले
Where is your plane?
appeal memo decided.
Lane, my lord, starts from page number 10.
Page number
10.
10. What is malicious prosecution?
Not, with my limited understanding, I'm not prepared on that as well. But,
No,
my case
no.
is that an FIR has been
No,
lodged
no.
against me.
Your suit appears to be a little misconceived. It ought to have been a suit claiming damages for the torture and ill treatment given to you in the police custody. Then you can make all these police officials as defendants and claim damages. That right we can recognize. But you have filed a suit for malicious prosecution. Malicious prosecution, the onus is on the plaintiff to establish that a criminal proceeding was initiated with an intention of malice. There is a difference between a wrong prosecution and a malicious prosecution. Not a single statement how to establish the malice. Think over it. Because unnecessarily, I can admit the appeal will be dismissed at one point of time. Now also, if you go, we can interfere and allow you to take a more corrective stand in the suit and convert it to a suit claiming for damages for cruelty and torture, etc. That is a totally different claim. Then you have to prove whatever was done to you, which is impermissible in law. So you please pay me compensation.
I'll take instruction on that.
Think about it.
Otherwise, the suit has been decreed in my favor. I'm here only for enhancement of that particular amount.
Suit has been decreed in your favor.
I'm only on the.
I thought it was dismissed.
No.
On what ground it was decreed? Where is the order?
The order starts from. The judgment starts from page number 33, man.
33. No, then we don't go into that question because they have not come in appeal. Although prima facie, I am not very convinced that it is malicious project. Page number?
It starts from page number 33, man.
33.
The issue is a 48, which I am. 48.
24 paragraph, page 47. I think malicious, you have to prove the malice. Malice, can it be presumed? Can there be a presumption of malice? Because every day we are holding the criminal court. Lot of people are acquitted. Even the trial court acquits a lot of people. Will every case be a malicious prosecution? Hmm.
We'll have to,
Possibly.
questions can be raised.
And how much of a cost was given?
5,000.
5 lakh. How much you want?
5 lakh.
Hmm. How much you will be satisfied with?
I paid for 1 crore, my lord. But
1
certainly that would be,
crore. 1 crore is too huge amount.
has to be, my lord. Because I
Something
was working, my lord. I was working as in a tea state, my lord.
you were working in a
I was,
working in a tea estate,
my lord.
and because of this cruelty inflicted, you could not,
My
you cannot
physical
work
condition-
anymore.
My physical condition completely deteriorated.
Okay, how much you were earning?
Uh,
What was the age when this incident took place, and how much were you earning?
That, my lord, I'll have to take instruction.
Hmm.
That I'll have to take
Suppose
instruction.
we borrow the principle of multiplier from the accident places and try to evaluate how much of financial loss was caused to you. Mental agony. We'll add the number of components and find out whatever it comes will be given to you. But we'll convert it to a judgment of not malicious prosecution, because this has to be corrected. Tomorrow a floodgate will open for every acquittal in any criminal case. It will be a presumption of malice, and malicious is not on presumption. Every wrong prosecution is not malicious. When do you want?
But, the IA for condonation of delay has come. I don't have the copy of the appeal.
No, delay will be condoned. As there is no appeal from the state side, we did not go into thing.
No.
But on our own, we intend to convert it to a.
But I would like to go to the appeal memo. I don't
Give
have
him
the
a copy of the appeal memo. We'd like to convert it to a payment of compensation, not on the ground of malicious, but on the ground of other averments made regarding torture and making the man unable to work. So you compensate the actual loss caused, plus something more
Well,
with interest. Whatever it comes, you take it.
let me have the copy. I'll go through.
30th month of this month.
Sorry,
30th of this month. The matter.
30 will be a good day. You don't want it before.
Can be before also.
See if it is possible,
24th,
because
my lord, it could be.
it tends to go out of our mind if a long time.
24th, my lord. It's not-
First, try to come prepared on what is malicious prosecution. Read that book of thought. One nice book is there. I've forgotten the name. What are the ingredients of a malicious prosecution, and what are the ingredients of a damage for torture, etc. And come with your actual figures of your income. What extent loss has been caused, whether any medical expenses were there, plus appropriate amount for the mental agony and cruelty that had been meted. We'll retain the compensation, see what more can be given, but definitely not 1 crore. And try to convert it to a compensation for cruelty that had been meted out, rather than it being a malicious.
But the appeal needs to be admitted. Yes,
Achha, we are still on the
on the condonation.
third, Mr.
R. Sensor.
R. Senswal and counsel for the applicant. Who could not be served?
Lord, if I may take my lord to order dated 10/3/2023, my lord.
Which of the respondent could not be served?
Service, it has been completed, my lord, to my understanding, my lord.
No, somebody said someone not.
I am appearing for 1, 2, 3, 4, 5, and 8. Others, my lord, I have no contact.
Mr. UK Deka is appearing for respondent
No,
number 10.
let him appear. All the respondents are served.
Yes, my lord.
It is stated that all the respondents are being served. Mr. D. Nath, Senior Advocate, appears for the respondents number
1, 2, 3, 4, 5,
1, 2, 3, 4, 5,
and 10.
and 10.
10.
But it is noticed that the other respondents are also
Oh, sorry, 8. Sorry, 8.
8.
Eight.
It noticed that the other respondents are also officials in the Police Department of the Government of Assam. And Mr. D. Nath, being the senior advocate to the Government of Assam, in our view, can also represent such respondents. This interlocutory application is for condoning the delay of 343 days in filing the accompanying RFA serial number 5569/2019. The ground stated in the application for condoning a delay is accepted. The delay of 7 days is condoned. Registry is directed to register the accompanying RFA and list it on data D20.
23rd.
List it on so-and-so.
But all the officers, what I could gather, they already retired. Most of them are retired.
That's
or
why he
they are
can
not-
represent because they are, after all, police of.
They are not in service. By name, they have been.
See, if we have to give specific cost against any one of them by name, then they may claim that, yes, we have a general right to be represented by a council of our choice. But as we are taking it on a general basis, mainly against the state of Assam, authorities under the state,
But during the course of hearing, we will indicate that.
you can represent everybody. And if you have to give specific cost against a given man by name, then we'll look into the issue, whether he should be represented by you or somebody else. Next, they come look into this.
Item 34.
And especially we want the information regarding those salaries and other things, medical.
And but in the meantime, the register may be directed to call for the LCR. It's a
The LCR of the TS number so and so.
LCR of-
That is so the Manisu.
Manisu.
Manisu number so and so be immediately called for. Yes, Mr. Alam.
Well, the substitution petition method with along with condonation and abatement method. Condonation is 1965.
1965 is for
19 is for substitution method.
substitution.
Of
And
legal
which
act.
one is for condoning the delay?
1966.
For condoning the delay. Delay of how many days?
869 days.
869
days.
Are you objecting?
They are already appeared.
My lord, I am appearing on behalf of my senior, Mr. Andy Bhuya.
Is your senior Mr. Andy Bhuya objecting to the delay being condoned?
I just told him, my lord, that only substituting the respondent number 2, my lord.
No, first we have to condone, then we have to set aside the abatement. Third stage is substituting.
Well-
So first issue, whether you are objecting to the delay. If he is objecting, I have to hear him. If he does not object, I can condone. What is your reply? When your senior will be ready?
Actually, it's not coming due to some personal problem.
When will the personal problems be over and he will be ready to appear in the court? No idea.
No, yes.
These petitions are pending since my lord.
That's why I am saying it's quite a old matter.
And they have already appeared for respondent number 2, my lord.
Respond,
Notices issued and they have appeared,
respondent number 2 is the regular respondent.
regular respondent.
And
They are appearing
and
for
the
legal
dead
aid.
respondent in the 2, they are related.
Related. And in the appeal, my lord, all are represented by them.
Originally for the dead respondent. When will your senior be available?
My lord,
It is stated that the learned arguing counsel for the respondents, Mr. Andy Bhuya, is having personal inconveniences and therefore cannot appear before the court today. It is also not stated by learned counsel, your name, D. Kuli, who appears on his behalf as to when Mr. Bhuya will be available to appear before the court. The learned counsel to file an affidavit before the court stating the date of his availability to list the matter. What can I do?
Item 35.
Yes, Mr. Young Counsel. Your senior will be on another problem to file an affidavit. Ask him when he will be available, we'll fix that date. Call up your senior, say the court has asked a question on which date he will be available, we'll fix that date. Please do that.
this is promoter revision. Actually,
So moto by the
yes, my lord. In this case, my lord,
so moto civil revision.
civil revision.
Why?
Civil revision actually, my lord, there is in a order passed in a criminal case, man. The order passed in a criminal case, the order was passed. Then that order, some remark was made against the one judicial officer by another judicial officer. That's why, my lord, he learned judicial officer made a application before this honorable court.
And based on that application,
That
this
application,
so
yes, has
moto.
been raised.
Where are the inappropriate observations?
That observation is, my lord, at page, my lord, 51. And your lordship statement goes to, my lord, page 53.
51.
No, no. So, page
Just,
50, so I
just-
keeping in mind,
Just a minute. This is the impugn order.
yes,
Means where the observations had been made.
yes, ma'am.
For whom do you appear, Mr. Nath? For whom do you appear?
My lord, he is from legal,
For the department,
for the
LR,
LR department.
judicial
and-
department.
In the
Acha, they
meantime,
also
my lord,
for whom do you appear?
and the
Legal Services Authority.
For number 20, the person concerned already sent their remarks by way of sending it with remarks to the extra general of the High Court.
Who person concerned means?
The officer against the CRPS fight.
Huh.
And his,
No, against whom it is being filed?
can
Yeah,
they name
No, just a minute.
he was-
Just a minute. The judicial officer who had made the disparaging remarks, he is a respondent here.
here,
For number 20, the two is post and the name of person.
But this, he cannot be made a respondent.
Entire
by,
registered by way of
No, even suo moto, he cannot be made a respondent. We can look into the disparaging remarks, whether it is sustainable or not, if necessary, expunge it. But
actually, my lord, by order dated, my lord, 29/9/2023.
হেৰি
He was
judicial হেৰি 86 or act act rule
There is a act on, my lord, yes. No, this is regarding remark on, my lord. that
Registry
they-
directed to inappropriate deposit.
By court order, he was made party.
You are appearing for the judicial officer.
I'm
Who appears for the judicial officer?
He has already said this entire bunch of documents, but the registrar general of the report, and it should not have been
So why we should not draw contempt against him?
priority or-
See, we never allow any other litigant to directly communicate with the registry. If somebody is rightly or wrongly a respondent, only means of appearing is either personally appear before the court or you appear through a learned counsel after due wakalatnama. There is no method available where a litigant will directly communicate with a registry. Communicating with a registry directly impliedly shows you are communicating with a judge. That is a contempt. Look into the law. Even government officers sometimes in exuberance, they do it, and we are preventing it. Mr.
Yes,
Nath knows
yes,
it well.
correct. In so many cases. I have
So
seen.
law cannot be different for a judicial officer. Ask him to remain personally present. Why he had directly communicated the registry? You cannot do it.
Right.
Firstly, maybe impleading the judicial officer may not be very correct. That is another aspect. But once having done so, you can only get yourself deleted from the error of respondents by filing an application, which you either move it personally or you move it through a learned counsel. The method of directly communicating with a registry is like communicating with the judge. That is impliedly a personal communication. What to do with this matter? Hmm. And mind you, we are not allowing this personal communication to anybody. Mr. Nath is aware.
Yes, yes, Lord. In so many cases, we have also.
Number of cases, we are quite strict. Hey, headache matter. RG ko naste. Ase.
But
It shows this person on the administrative side, why he is directly communicating with it. And where are the disparaging comments?
Page 53, my lord. Page 53, my lord. Page 53, my lord. So keep, has your lordship got it? Page 53, my lord. Paper book. So keeping in mind the forbearing approach, a learned
So keeping in mind a forbearing approach,
the learned secretary district legal service authority Dhupuri is advised to be more vigilant and more judicious while writing a letter to the senior officer, particularly in respect of the court matter, because any carefree attitude may be affected adversely the dignity and majesty of the court.
so why he is saying that what did he do?
Then your lordship kindly, my lord, come.
Just a minute, let me read the whole order.
Page 42 is the letter.
Just a minute, the report. What is this matter? Sessions case?
Actually, my lord, what happened?
No.
Yes, session case.
It's a session case.
Session.
Can an assistant session judge take up a sessions case?
No, sometimes power is delegated.
Hmm.
Power is delegated. So
By whom?
By district judge.
District
session judge. Session judge delegated the power to the my lord assistant session judge. So he is.
Is the delegation power available?
That is my lord in certain cases I have seen that is there.
No, it is done. Is it available?
The district session judge.
No. Assistant session, additional session judge is a session judge.
Additional session judge is
But
more or less same as session judge.
Assistant is not. Assistant session judge is not a
Now, in that respect, there is a matter, my lord, there is a judgment of our High Court also. Sometimes, my lord, power delegated, and he has done, if he, my lord, he has up to certain amount, a certain conviction, he can, my lord. Above that, my lord, for the sentence, it has to be confirmed by the district judge. There is a judgment of our High Court, my lord.
Let us see the judgment.
That not now, my lord, my lord. I'll place, my lord, if your lordship fixing next date, my lord, I'll take.
Mm. We are listing it tomorrow,
Not tomorrow.
day after tomorrow. Hmm.
Monday, Monday, my lord.
That's why. No, let us list it day after tomorrow for some other purpose.
My lord,
Huh?
my lord.
We'll require the
But with
registry
other
to take up
things,
why,
that issue, I'll.
why is he directly communicating with the registry?
Yes, my lord, he has.
That has to be taken up first.
My lord.
From the registry, he can be informed, right?
No, if it's a formal notice as a respondent in a judicial proceeding, you are precluded by your status otherwise as a judicial officer to directly communicate. Had it been administrative matter, yes, but not in a judicial matter. You cannot. In a judicial matter, once you are a respondent, rightly or wrongly, you are a litigant before the court. And once you are a litigant, you are debarred from directly communicating, whatever it is. No, we'll accommodate you because we have to speed up this matter to some extent. Okay, no, then that is okay. No difficulty with that. No, all hit we corrected you.
My lord.
And regarding this delegation, please produce the relevant.
No, my lord.
To what extent delegation is possible? Because otherwise, where is the provision for a sessions case? CRPC? Your class of cases is section 6. 1 is court of session, 2 is judicial magistrate first class, 3 metropolitan. And court of session.
Court of session, that is, my lord.
Section 9, state government shall establish every session be presided by a judge to be appointed by the High Court. May also appoint additional session judge and assistant to exercise the jurisdiction in a session, court of session. Okay, it is there.
156.
In a court of session.
220.
And what is the original matter?
My lord.
Original matter in sessions case 36?
My lord. So, case 36.
Originally, sessions case 36 relates to 420 and 120B. Maximum punishment is less than 10 years. I think it's less than 10 years. Hmm.
The issue arose, considering the fact that there was these orders being passed by the apex court saying that those UTPs, underground prisoners who have been languishing in jail only because of the fact that they're not able to produce the surety bond should be released in several cases. So that issue arose between these two authorities, between the person who was the petitioner and the respondent number 2 and 3. Some kind of communication was made with the person where the petitioner wrote an incorrect finding of fact. They're taking that into account.
No, if the secretary DLSA had recorded incorrect finding of fact, it is a case of misconduct possibly, or maybe something to be taken up in the administrative side.
What happened was, in fact, that this gentleman, the spot number 2 and 3, instead passed a judicial order saying that we have not granted bail to that particular person. And how is it that you have submitted a report saying that bail is already granted? So that became the issue, and a report was called for. And while giving the report, the answer to that particular report, The petitioner also wrote to Honorable Chief Justice and the saying that the remarks which have been passed against him, that is the basic summary of the matter.
Correct.
Whereas the
No,
Honorable-
disparaging remarks will have a bearing in the service career.
was a very, it was in the form of an advisory, but yes, there are two sentences which were perhaps not really parliamentary language.
Discussing.
Two sentences that page
Discussing.
52 from a lot, royal order.
Page 2.
52. The second paragraph.
Beating around the bush.
Yes. And page 50, second paragraph. Again. Although he notes the authority number 2 notes that error might have occurred because of this particular reason. And then he gives a small advice at paragraph 4 of page 52.
That could have avoided by not reflecting in the judicial. Could have.
To advise, he could have brought it not to the notice of the district judge. District judge would have given the advice if necessary. Then dispose of. Ultimately, what did he do? With the above observation and suggestion, matter relating to Secretary so-and-so put up on basis of his letter stands disposed of. Ultimately, what did he do? He himself did, what did he do?
Page 51 policy.
Uh,
Case
it
reporter
is-
put up before him
Huh?
by letter
Was asked to
4/4/23.
No, he writes everything other than what is the issue that he had judicially determined.
Which
Reply.
line. That above.
What?
But the page was regard to the.
I understand that. Why was this order passed 5/4/2003
It was a inquiry report called for.
from the?
From the, from the
Secretary?
High Court has been pursuing this under trial.
Okay.
And the DLSA was asked to submit a report. as to
Huh.
How many are there in the Dhubri district?
Okay.
King at court reason.
The DLC secretary had submitted some wrong report. So, so the High Court will act upon that. What necessitated a judicial order dated 5/4/2003 and what is the purpose of this order? Why I am saying so, had there been a specific judicial decision and direction, I understand, but it does not do anything. The matter relating to secretary dated so-and-so stands disposed of. What did he do? Ultimately, judicially, what was done?
Issue was relating to reducing the condition in the bail bond.
We understand everything.
That application was put.
If this court of session would have granted bail to that man or would have allowed him to,
In fact,
then I understand that judicially some decision had been taken.
No.
But what judicial decision was taken?
in fact,
I'm unable to understand that.
in a pending PIL, ultimately the steps were taken.
Mr. Nath, background, I'm not interested. I am just asking you what judicial decision was taken by this order.
He has rejected the application filed by the DLSA for reduction of that condition in the bail.
You
particularly
cannot do that. That is pursuant to Supreme Court orders. DLSA, what mistake did he make? What mistake did he make?
Order, it was passed by the Supreme Court also correspond to the apex court. Foreign nationals
Understand.
are slightly different. The order which was passed is that they, such nationals, if required, should be moved to the detention center. Whereas this gentleman's petition included the name of this particular foreign national in the list of UPPs which were considered to be citizens, and he said they should be released on bail per se. That was the mistake that was committed by the and thereafter this entire scenario occurred.
So if he had passed a wrong order, his order should be interfered to release that man.
Yes.
But that interference is not there. It is only says disposed of.
Application is
Giving a few advices here and there, he disposes it off. Ultimately, what happened to that man? He's released or he's still inside?
no trial is going on.
Trial is going on.
He's released.
No,
he's not
Not
he's,
really.
he's inside.
Probably not really.
Foreign national, he is in jail.
He's in. He's in.
And is he entitled to be released or is not entitled to be released?
He's per se. And another, there's another
I'm
aspect.
not even clear about the factual background.
Uh,
This man, as per the order of the Supreme Court and the matter persuaded by High Court, he's entitled to be released or he's not entitled to be released.
No, he is entitled to be released to the detention center.
So has he been sent to the detention camp?
It is
Why
So,
not? He's still entitled.
so that means the Court of Session did not do its judicial work.
No, they have,
He should have,
he had.
apart from advising, he should have also sent this man to the detention camp then.
That, not mistaken, that order was passed.
The original cause still remains.
I do believe he had passed that order.
Where is it?
It is, the entire case was considered by the court in, and so B, if you're not kindly take up the, comments which have been sent by the.
I'm not looking into comments. We are not bound to look into comments.
Entire,
Itu kiba ata itu kiba ata order that there is some disparaging comments against another judicial officer who is the
Only what it and only related to cases 123 and 420. But they have not. No, bail was granted for committing, before committing, but after committing charge stated.
No, why did I look at it really? He's not a Bangladesh. No, what did he want? Oh,
1922 to comment.
no, he is here. Yapan online.
Yapan.
Yapan online.
Yapan. Is it
He's 120 PY, not 420 into he
তার নিজরে গিয়া এটা বাংলাদেশ পেজ নাম্বার 19 হোক আপনি of his own petition.
This is not his petition. Don't say that. This is not his petition. Don't say that. He's
I'm not against you that.
His petition total Udiana. Petition registered is very problem.
Econol, আমার লিস্ট আমার এই ফটো কেসেতে এটা ইউটিপি এটা ইউটিপি জেলত আছে একটা ভুল রিপোর্ট ভুল রিপোর্ট করে আমরা বেসিসে জুডিশিয়াল অর্ডার একটু বলে সেটাই তো কথা he judicial order the authority with got a ভুল
Point number 2 to the Registrar General.
I was provided a bunch of documents from the respondent number 4 office.
Occupant silo boston. Please show it to the Registrar Vigilance.
I'll share a copy.
Copy was sent to me also, my lord.
Again,
Copy was sent to me also, my junior also.
Copy has been marked to us also, and this has been
Sending to you is a more of a contempt. He's trying to directly communicate with the adversaries in a litigation.
and this has been
Please take it up and do the needful.
copy has been given to us also, and it is seen and forwarded by the district.
And not only that, my lord, another thing I have to be pointed out, that was, my lord, served by Jari Karawat.
To?
That district court Jari Karawat came to me, my lord, to my junior, my lord, and that is served on me, my lord.
How can you, how can you do it?
When then, my lord,
Or Raskwa?
how he can personally send things sent to them at all his official.
Mr. Registrar Vigilance, take note of the statement of Mr. T.J. Mohanto that this communication was served to him through a Jari Karak from the office of the district judge. How can you
Yes,
do it?
from the office, Shilostadar office of the.
Judicial authorities, when they exercise judicial jurisdiction, the method is different. But when you are exercising your administrative jurisdiction, you cannot invoke the judicial method to
And
issue a.
not only that, signed by Shilostadar, my lord.
Please take note of this and take up with the district judge also. Why it will be done?
I am not yet open. It is being there.
And why a learned, Mr. Raskwa? Why a learned senior counsel appealing for the High Court will be put to this kind of a ignominious situation?
That's why I am not yet open, my lord. My junior had opened, my lord, but I have not yet.
They rightly done it. And that way Jari Karak, means
Forwarded
what?
by the Shilostadar.
What does a Jari Karak do? They serve notice. Is it a notice from a court? Please take note of it.
And in fact, my lord, he taken signed by my junior in the, my lord, official notebook, my lord, of the Shilostadar of the district court, my lord.
We'll call for it. Not be done. And small things you are aggravating to a larger issue now for nothing.
But some guideline has to be there. Otherwise, our officers also, even they are time and again, we have been advising them, but they are still repeating. Some officers are still there. Some
Directly to the court.
yes, yes.
Directly committing to the registry, we have checked up the contempt law. It's a contempt.
I have seen.
You cannot do it.
In fact, still.
So
still,
if a person in position that these people can do it, if a senior government official can do it, why the private litigant cannot do it tomorrow? What prevents a petitioner tomorrow directly coming to the judge and saying, please look into my case, this is what I have to say? Why that man is prevented? Litigant is a litigant before the court.
Yes.
There is no class of litigants.
Yes.
All are equal litigants. Tomorrow then we'll allow everybody in the street. We'll open a market in the front of the court premises. Judges will be sitting on a table in the chair. Please come, whatever you who has to say what. Why it will not be made open in that way then? If you allow some category of litigants to do it. Law is equal to all. Please take note. Mr. Mohanto will take note. Wait, take note. Rest of the matters will list immediately. And this one day after tomorrow, will accommodate your absence.